Good afternoon. There's 6.5 hours of oral arguments scheduled. So I have to remind you that we have had your briefs and records. We are familiar with your cases, and we just want you to ask for the time that you really need to make your important points. We will, of course, ask lots of questions. And when the red light goes on, you should be finishing up what you have to say. If we still have questions, we're not really bound by the red light, but you should be. Okay, so let's call the calendar. The first, and if both sides will just stand up and let me know how much time you think you would like. The first case is People versus Barajo. Okay. 5, 2, and 5. Martirana versus New York City Fire Pension.
Appellant requests 5 minutes and 2 minutes for rebuttal.
Okay, and respondent? Okay, 5, 2, and 5. H. Samaya is submitted. Bay Plaza versus Cablevision Systems.
Respondent requests 5 minutes.
Well, we'd like the appellant to go first.
Appellant 8 minutes and 3 minutes. 5 minutes, Your Honor.
Okay, we're going to give you 5 and 2 and 5. If we need additional time, we'll work that out. The next case is Cohen versus Gordon and Silber.
Good afternoon, Your Honor.
Appellant.
Appellant requests 6 minutes and 2 minutes.
Okay.
Good afternoon. Respondent requests 5 minutes.
Okay, we'll do 5 and 2 and 5. Ponce versus City of New York. Okay, and the other defendant? Okay, so I'll give you 5 and 2 and 5 for you and 3 for the third-party defendant. Thank you very much. People versus Arthur Hernandez. Okay. You got it. 5, 2, and 5. Sarah Studios versus Sparkle World is submitted. Kagan versus Medazade. Sorry if I mispronounced that. Okay. 5, 2, and 5. People versus Javier Alvarez. That case is submitted. South Street Seaport versus Landmarks Preservation. We have 2 appellants here and 1 respondent. That's the city appellant, you say? Okay, and okay, and the respondent. Well, I'm not going to do that, but we'll give you 8. I'm sure that will be enough. Thank you. So everybody got what they asked for, except I gave you a little less. Zinger versus Robertson. Okay. Respondent. Okay, 5, 2, and 5. Optical Communications versus Worms. Okay, and respondent. Okay, so I'll give you 6 and 2, and I'll give you 5. People versus Sherman Harrison. I'll give you 6 and 3 and 6. Thank you. Adolph versus Hill Kirby. You are whom? You're the respondent. There's no appellant. Do you want to just have us mark the case submitted? Okay, well, we don't usually do a second call here, so we'll mark it submitted. If anything happens, if the person shows up in the next couple of minutes, you let the court officers know and they'll bring it to our attention. Thank you. And the last case is Barisi versus Hall's Boat, and that case is submitted. Okay, thank you. The first case for oral argument is People versus Barajo. Okay, good afternoon. You may
Good afternoon. Catherine Picor with the Legal Aid Society on behalf of Mr. Barajo. Pursuant to this misdemeanor repleter agreement, Mr. Barajo completed 40 hours of his required community service, 35 and a half of 36 hours of his alcohol treatment program, the educational prerequisites leading up to the GED test. He also paid off $600 in DMV fines, had no new arrests, and came to court as required for over a year for the duration of the repleter.
Counsel, in your brief, you characterized this as substantial compliance, but he didn't do all the GED classwork, did he?
So the understanding of the parties, beginning a few months before sentencing, defense counsel is coming into court saying he just needs to take the GED test, not the program. That's, I think, for at least 6 months, counsel was making that representation. During that time, obviously, the parties conferred. The prosecutor never said anything to the effect of, that's not correct, that wasn't her understanding. And I think we have to read this record sort of as a whole. At sentencing, I think the only reason why that was disputed is because there was a different ADA, there was a different judge. Nobody was really familiar with the progress of the case, and it became a bigger issue, I think, than it was before.
How about the VIP program, though? That was another thing he did not do.
So I don't think it's clear that he didn't. At the time of sentencing, defense counsel represented that the only requirements he had left were 30 minutes of treatment and the GED test. She was very clear about that. Now, I will agree that this record is not a model of clarity, certainly at sentencing. And the VIP program wasn't mentioned again. So I think to the extent that it's a close question, I believe this is the appropriate kind of case for this court to exercise its interest of justice power, given that, he did end up completing well over 100 hours worth of combined programming and community service.
Counsel, if I may, let's go back to the GED, because June 8th, defense counsel claimed that defendant was going to take the GED by August, but September, there was a student enrollment policy that he signed. So how can that be? He was going to take it by August, but then in September, usually when you are enrolling, you sign something. So in September, there was the signature.
I agree, it's not exactly clear what programming he had completed prior to the GED. But again, defense counsel has been consistently representing that he just needs to take the test, he just needs to take the test. And I think considering that the parties had conferred during that time, that was never really disputed. I think that deserves some deference. And
Well, counsel, defense counsel is representing based on representations most likely that the defendant makes to defense counsel. And as an officer of the court is bound to take that representation as truthful. But when we look at the documentation says something totally different from the representations that are being made to the court. So which of the two should we, or should the court have believed at the time of sentencing? Because that was a big thing. The court is hearing the representations of counsel and then is looking at the documentation and noticing that most of the representations that are being made are not backed up by the documents.
so I would disagree that the representations are not backed up. And I think the minutes that respondent is identifying as potentially inconsistent with the documentation.
Let's go back to the GED
Sure.
form that Justice Kennedy brought up.
Sure.
That form is signed on September 13, 2018, which was weeks before the sentencing. So if he's signing that GED form in September, he's going to be sentenced sometime in September, October, yet he should have been completing that GED program and should have been participating for months. But that's not what the documents show.
So I think part of the issue is that 2 of the appearances preceding the sentencing, There's a different attorney there standing in for defense counsel. I think perhaps he might have been not super familiar with the facts of the case. I don't think that there was any, deliberate misrepresentation. But again, defense counsel had been stating since March 2018, and sentencing is in September 2018.
But where are the documents to back up what the defense counsel is telling the court in March of that year, or even the previous year? Let's not forget that
Yes.
this is a conditional plea, and he was supposed to complete those conditions within 6 months. And now we are more than a year later, and still, most of the conditions have not been satisfied.
I would not agree that most of the conditions have not been satisfied. First of all, I think this court needs to take into account, that he couldn't even begin some of the programs before he paid off his fines. This is a 19-year-old who has no way to get around, has no way to get to programs. It took about, I think, 6 months for him to even get to enroll in programming and then identify programs he could attend, because he's living upstate. He doesn't have a license, he lost his job, he doesn't have a stable home. And I think these are all factors that this court should consider. I would agree with you, the documentation is not as clear as it could have been, and that is what it is. I think certainly it would have been optimal if defense counsel had come more prepared at the time of sentencing. But there was never any suggestion by anyone below that either defense counsel or Mr. Barajo had misrepresented what was going on. I don't think that that's at all what we're dealing with here.
Okay, let's hear from respondent, and you'll have a couple minutes on rebuttal. Thank you.
Good afternoon, Your Honors. Franklin Gunther on behalf of the people. Defendant's conviction should be affirmed. First, defendant expressly waived his right to appeal the terms of the plea, knowing full well the conditions he would be asked to complete at the time he accepted the people's offer. And under this court's ruling in Thomas, that waiver forecloses review of this claim. Second, the record indicates the defendant was nowhere near substantial compliance with this agreement. Defendant was given 6 months from July of 27 to complete the 4 conditions of this repleader. And at the conclusion of that 6-month period, he hadn't completed any of them. Nevertheless, the court and the people consented to 5 additional adjournments after the initial period to give defendant sufficient time to complete the conditions. Yet by September of 2018, the only condition the defendant had completed was the 5 days of community service. Despite these shortcomings, the court still gave defendant most of the benefit of his bargain by sentencing to the same $300 fine and 90-day suspension of his license that he would have otherwise received. That leniency and the extent to which defendant fell short makes this case readily distinguishable from cases like Perez and Grant and Jimenez. And unless there are other questions, we just ask that you affirm.
Thank you.
I'd just like to step back a little bit from the specific conditions in the documentation to just make the point that we made in our briefs, which is the interest of justice is not served by giving Mr. Barajo a permanent criminal record solely because of this one case, this misdemeanor, for an offense he committed when he was 19, given how hard he worked to complete these programs to the best of his ability against very significant obstacles. Lack of transit, lack of financial means are very significant for a 19-year-old. And I think the purpose of the repleader agreement, it wasn't so much about sentencing. It was about the parties wanted to give Mr. Barajo an opportunity to avoid an adult criminal record because of this one case. It was not to throw the book at him. It was not to be overly punitive. It was to give him a chance to have some resources, some treatment, some programming, and to stay out of trouble in the future. And I think those goals were achieved here. And in view of those larger goals, this court should reduce his conviction in the interest of justice to the promised traffic infraction.
Okay, thank you. Thank you both. Next case for argument is Martirana versus New York City Fire Pension Fund. Good afternoon.
Good afternoon, Your Honors. My name is Philip Seelig, and I'm representing Petitioner Appellant Battalion Chief John Martirana. John Martirana is a battalion chief in New York City Fire Department, and after a final Board of Trustee remand to a medical board that makes a decision on his application for accidental disability, on October 16, 2019, they found that it was a disabling neuroma and that neuroma predated his July 2nd, 2017 injury, and that there is no new evidence that the neuroma was due to any traumatic injury in the past.
Couldn't the medical board discount Dr. Roberts' testimony, or rather his report, because he reviewed the MRI and didn't mention the neuroma?
Yes, but there was an MRI, and it did say that that the neuroma was adjacent to the same second phalangeal joint where there was a plantar plate tear. And in looking at the standard of Tobin v. Steisel, as you're acutely aware, if there is a pre-existing condition or a latent condition, a pre-existing condition that's aggravated by a line-of-duty accident.
Did you argue that position from the beginning or make that aware that?
Several times.
An aggravation of a pre-existing or?
Yes, several times at the Board of Trustees. I myself argued about that, and on one occasion, the Board of Trustees remanded it back to the medical board on their third evaluation of the applicant, and specifically asked them, the medical board, to opine as to whether or not there was a Tobin v. Steisel criteria that was met. And instead, they articulated this one statement that there was no pre-existing injury, which is not the correct standard. As you know, the very nature of Tobin v. Steisel is that where there's a latent condition or pre-existing condition, the question is whether there was an aggravation of that pre-existing condition or a precipitation of the development of a latent condition caused by an accident. And that's what exactly happened here.
Did any of the doctors that examined Mr. Chief Maturana say that the neuroma was aggravated by the incident?
No, I did in legal arguments on memorandums of law and also verbal arguments to the Board of Trustees. They all held, all three doctors, orthopedic surgeons, felt that it was the plantar plate tear that was disabling, not the neuroma. But the medical board found it was a neuroma. And the problem with their flawed reasoning is two major reasons for this court to consider remanding this back for further consideration or overruling that recommendation. First, it cited, or the medical board did not comprehend what the Tobin v. Steisel standard is. And they dismissed the notion of an aggravation by just stating that it pre-existed. But that's not dispositive under the Tobin v. Steisel standard. It's exactly what all Tobin v. Steisel claims are, that there was a pre-existing or latent condition. So that's not a reason for denial. The second is that it failed to provide a medical explanation for their ignoring the possibility of an aggravation or any pre-existing condition, which was that neuroma, which doesn't provide this court an opportunity to have a judicial determination or review of that determination by the medical board, or that recommendation. And in order for this court to really determine whether they were correct or not, they have to at least articulate their reasoning for being so dismissive of the notion of an aggravation.
Counsel, there were 4 medical board reviews. Each one was consistent with each other, correct, in finding that it was not in the line of duty causation. I mean, that's kind of, am I correct? I mean, there were 4, I mean, they were all consistent with each other, saying, no, this is not it.
Yes, that's correct, but it's not a matter of how many times, it's whether or not they met their adequate legal standard when reviewing it. And so just repeating what they've done before, it does not justify a denial by this court of our application for a remand or overturning it. There is this Tobin v. Steisel. It's a Court of Appeals case. It doesn't apply in every situation, but it clearly should apply here, especially since the plantar plate tear was at the second metatarsal a phalange, which is exactly where the neuromer was placed, in that same second metatarsal web. And so the notion that it was coincidental where it was asymptomatic, he was operating full duty capacity, had an injury, within a week he was at MRI was taken, and it showed marked edema, which is swelling, caused by a plantar plate tear of the second metatarsal joint, and that's exactly the location where the neuromer sits. It was swollen, it was inflamed. The medical board found him disabled for the neuromer, and while we disagree with that conclusion, we have to at least consider, and the medical board should have considered, whether that neuromer was made to become inflamed by that plantar plate tear immediately in the same vicinity and
Okay,
at the same
counsel.
time frame.
You'll have a couple minutes in rebuttal. Thank you.
Good afternoon, Your Honors. May it please the court, Susan Paulson on behalf of the Respondent Board. Your Honors, this is not a Tobin v. Steisel case. As Justice Mendez pointed out and my adversary conceded, there was no medical evidence here that the line of duty injury aggravated a pre-existing condition. In Tobin v. Steisel, the petitioner's medical record stated that his service-related accident was a precipitating cause, and that's what's missing here. The petitioner bore the burden on causation, and notwithstanding the fact that, as he conceded, it was sent back specifically for the medical board to consider aggravation, as he had argued to the Board of Trustees, and as he argued in his brief, he did not elicit a medical opinion from any of the three doctors, Dr. Roberts, Dr. Zarat, or Dr. Chapman, asking them about aggravation. So there was simply no medical evidence in the record indicating that the service-related injury had aggravated the pre-existing neuroma.
Should the board have taken it upon itself then to look into whether or not this neuroma was aggravated by the incident?
I mean, especially because of the fact that they were so close in the part of his foot where the injuries were, is right in the same area. Wouldn't that have been something they would have looked at? Did they look at it, and what did they say?
Your Honors, the medical board looked carefully at four separate medical reviews at the x-rays and the MRIs and the results of the examination. And it did specifically find, if you look at the record on page 72, that the neuroma was not secondary to the incident. So based upon the clinical findings that they identified from the medical records and from their examination, they determined, and there was no contrary medical evidence suggesting that it was aggravation. And I'd like to point out that the medical board did not just do a cursory review or not explain its decision here. It identified the specific clinical findings that supported its decision. It found that the neuroma, that there was tenderness directly over the area of the interdigital neuroma, that there was decreased digital nerve distribution in the area of the neuroma, and that the squeeze test, squeezing the toes together, produced pain in the neuroma area. This, they thought, was a source of the pain. In addition, they identified the clinical findings that supported their determination that it was not the partial rupture of the plantar plate that caused the disability. They noted that the clinical findings established that there was no instability in the midfoot from the partial rupture, there was no weakness, that the dorsiflexion and the plantar flexion of the ankle were within normal limits, and that there was a normal plantar arch. So although the petitioner's doctors disagreed with their determination, the medical board reviewed the medical evidence and provided credible medical evidence that supported their determination that it was the neuroma and not the plantar, the partial rupture of the plantar plate that caused the disability. And again, I would just remind this court that the petitioner bore the burden of causation, and notwithstanding 4 medical reviews, did not elicit a medical opinion on the issue of aggravation. He had several medical opinions that stated that his doctors believed that the disability was caused by the line of duty accident and not by the neuroma, but none of them weighed in on whether or not the line of duty might have aggravated. In the absence of any medical evidence to support that conclusion, the medical board properly concluded that the accident disability retirement benefits should be denied. If there are no further questions, thank you, Your Honor.
Thank you, counsel.
Well, contrary to opposing counsel's comments, the medical board opined on May 22nd, 2019, and the third time that they've said the same thing. In their conclusion, it's on the record at 68 to 70 on the respondent's record. BC, meaning Battalion Chief John Matarona, is permanently disabled due to his left foot second metatarsal plantar plate.
Well, what
So
was
there-
what was the medical evidence that you submitted? Because
Medical
counsel said there was no supporting medical evidence presented by you to the board for them to review to find that there was an exacerbation of this condition. So can you point out to us where in
Yes.
fact there is that medical?
The medical evidence was the MRI, all of the medical documentation from his own doctors, the fact that the board of trustees itself specifically requested that the medical board answer the question of whether there was an aggravation. So it was up to them to answer that question.
But in the
and
end, they decided it wasn't.
No, they decided that it wasn't because there was no prior injury or trauma, but that's not the test under Tobin v. Steisel. So they responded in a way that didn't meet the appropriate legal standard, both because it is not a Tobin v. Steisel standard to dismiss it merely because there was no history of a prior injury. You don't need a prior injury to meet that burden. And secondly, it didn't provide any credible medical explanation for this court to review to make a judicial determination as to whether or not they've adequately denied under the Tobin v. Steisel standard. Thank you very much for your indulgence.
Thank you, counsel. Thank you both. We will review those papers. The next case for argument is Bay Plaza versus Cablevision Systems. Good afternoon.
Good afternoon. Richard Blumberg for Appellant Cablevision. Your Honors, the trial court, when they granted landlord summary judgment, confused the vacate date and the termination date. My client, pursuant to its option to terminate the lease early, submitted a notice setting forth March 31st as the termination date. When that date came around, there was a dispute between the landlord and the tenant regarding the condition of the premises and how it was supposed to be left. In a classic no good deed goes unpunished scenario, my client stayed, tried to appease the landlord, and made certain changes to the building and actually vacated on June 30th.
I mean, you essentially complied with the 60-day notice requirement, right? You have to give 60-day notice before you terminate the lease. That's what happened here. I think it was sometime in January or something like that you sent out the notice that you want to terminate.
That's correct, Your Honor. In January, we sent out a notice.
And you never got a notice back saying you're in default of any provisions under the lease.
Not only do we not get a notice back, Your Honor, we paid $1 million, over $1 million
There
for
was
the right.
a 6-month fee. It was like termination fee, early termination fee.
Correct. Never returned by the landlord. In the complaint, never referenced. They kept that. And critically, they never sent a notice challenging our notice to terminate. And the Court of Appeals in JFK Holdings said, if you keep the fee and you don't send a notice rejecting the early termination, then you ratified it. And that makes perfect sense here.
But I guess then is that why do they need, well, I guess, you know, they should send a default notice, but their claim is that you weren't paid up with all your rent when you sent that, when the termination notice, the termination date was going to come forth.
Your Honor, that's their claim today. That wasn't their claim in their motion papers, so let me explain. The trial court held that my client hadn't paid all the rent as of the vacate date. That was May and June. There was never a claim and certainly never a finding in the trial court level that my client owed money. Now they're claiming that we owe $38,000 through the termination date, which was March 31st. We consistently dispute that. So there's been no finding on that issue.
And there's not really that much adequate documentation to back up the 38,000 from, I think, 2013 that they claim you owe, correct?
Your Honor, not only is there no backup documentation, when they finally submit a spreadsheet after the termination date and 4 months after our notice, they reference monies that were due in 2013 and 2018 in support of it. So here we terminate in 2021, termination date passes, and all of a sudden they send a general.
And you had never gotten a previous notice that said anything about these amounts that they're now claiming you owe?
Absolutely not, Judge. So we never got notice of it. There was no cure period of it. It's like an ad hoc position that they took in order to justify them trying to terminate the lease and keep the $1 million from the court. So
Now, under the lease and the 2018 amendment, there's a distinction, right, between the termination date and the vacate date.
that is correct, Your Honor. The termination provision, or the early termination provision, only talks about a termination date, no reference to a vacate date. And the vacate date and termination date are quite often not the same. That's why the courts are inundated with holdover proceedings. Termination dates come and go. But the trial court treated them as one and the same and made a determination that since money was apparently owed, and by the way, those monies were paid in October, so it wasn't like any money did not go back to the landlord. But they made a determination that since monies were owed up to the vacate date, that they would relate it to the termination date, and that was inaccurate, and that was an error, and requires reversal. Any other questions?
Okay, so let's hear from the respondent. You'll have 2 minutes to respond. Thank you. Good afternoon.
Good afternoon, Your Honors. May it please the court, Jonathan Lynn from Oved and Oved for the respondent plaintiff, Bay Plaza Community Center, LLC. The court should affirm the decision because tenant is asking to be.
Wait a minute, you get the notice that they're going to terminate. It's within this, it's the 60-day notice, but there was no default, that you didn't send them any notices of default saying that you default under the lease. You didn't pay us the rent that you're supposed to pay us, or anything else that's defaulted on the lease. So, and you waited to the 11th hour, and then all of a sudden you say you owe us $38,000. So, you know, you're not entitled to terminate the lease. So why should we affirm the Supreme Court in that regard? Because you didn't do anything.
Well, Your Honor, that's.
Unless I misread the record, which is quite possible.
I believe that's correct, Your Honor.
I am correct.
No, I believe that you misread the record.
Oh.
The early termination clause required the tenant to have paid up all
Yeah,
rent as of the date that they're terminating.
Okay, but
So it only becomes relevant at that 11th hour whether they've paid or not.
wait a minute. Are you kidding me? You mean you're going to just let the 60 days go until the 59th day? You're going to say, oh, aha, you didn't pay up. You're in default. That's kind of.
The problem is you never sent out a default notice to let them know about this amount that you claim is due until afterwards. How are they supposed to pay it if they don't even know it's due? You never let them, you
And
never
on
let
top
them
of
know.
that, they're paying the $1 million termination fee too. So, you know, you got the termination fee, and then now you're going to wait till the 11th hour or the day after and say, no, you know what? You're not entitled to termination because you were under default under the lease.
Okay, now I'll let you try to.
Well, Your Honor, the notion that there was never any notice provided about the funds that were owed is simply incorrect. There was a subsequent brief in the trial.
No, point to the record then that you said that there is a notice of default then.
There was no notice of default sent after the termination notice. That's because Section 17 of the lease did not require a notice of default with respect to any monetary defaults. It was only with respect to non-monetary defaults that a notice of default was ever required. So the fact that there was no technical notice of default is completely irrelevant to whether or not the attempt to terminate the lease.
So you're saying that you could actually, the tenant could owe you rent over many years, beginning in 2013, 18, 19, 20, and then in 2021, they say, we want to terminate the lease, and that's when you let them know, well, wait a second, you owe me money from way back in 2013, and before, you can't terminate this thing until you pay me all of that money that you owe me from all the way back then.
No, Your Honor. The issue is that they were not just told after the fact that they owed the money. They were told they owed this money in 2018.
Well, the only notice that I have here, that I see in the record, maybe like Justice Owen, maybe I misread it, but the only notice I have is dated April 22nd, 2021, and that's after the termination notice took effect.
Correct. That was after they had failed to comply with the early terminations clause requirement to be paid up at the time of
So
termination.
when were they supposed to know that they owed you any money?
In 2000
2013, 18, 19, 20, when?
At least as early as June 2018, according to docket number 56 in the lower court. That reflects an email from the landlord to the tenant.
Well, that alone, because of the dispute here, wouldn't that warrant you not getting summary judgment? Because their position is, we didn't owe you a dime. And you're saying, yes, you did. So right there, you have a little bit of a dispute there, unless you can point something to the record that says, no, they knew ahead of time when they served us with a default notice that they were behind in rent. And irrespective of where you're saying that, monetary defaults, we don't have to issue any defaults. But right there, isn't there a factual issue right there? Because they're saying we don't owe you anything, and you say you did.
No, Your Honor, there's no factual issue because there was nothing but a conclusory denial that the sum was.
But in fact, I thought there was something more than that because they said we had our procedure was to zero out anything that we might have owed at the end of each year and make sure that we were okay before it goes on. They put in an affidavit that said that. You didn't say, oh, no, that's not how you acted. That's not how our relationship was. And there really was not enough to back up your numbers. So your claim is somewhat conclusory, and their claim was, based on something. How do we make that decision on summary judgment?
Well, 2 points, Your Honor. First, there is documentation for the landlord's position. He submitted the spreadsheet, the claim of exactly what money was owed at the time of termination. There is no similar documentation from the tenant with respect to their conclusory denial that the money is owed. So that by itself disposes of that issue. But
I'd
independently,
like to bring up another issue because I know there's a claim that they breached the lease because they didn't fully vacate and not remove their personal property. But can you point me to the lease and to the amendment where it indicates that, that was a precondition to an early termination of the lease? I didn't see it.
that is section 22 of the lease, which is at record page 33. It's a requirement to, at the end of any termination, to vacate the premises and surrender it in broom clean condition with all personal property removed. There's no dispute that that didn't occur here, and that by itself is independently fatal to any attempt to terminate the lease. The whole point of terminating a lease early is we're going to leave. They didn't.
But isn't that the argument that they're making, that one thing is termination and another thing is vacating? So that they say, we terminated and now we have to vacate. But before we leave, we got to bring it back more or less to the condition that we found it in, which is what council says is what they were doing, and it's why they left in June instead of leaving earlier in sometime in March.
That is their argument, but there's absolutely no support for that position, that reading of the lease in the record. It's like saying that I'm going to take out a hotel for this whole week, and I'm going to actually check out 2 days in, but I'm still going to stay in the hotel room. That's not how it works. If you're going to terminate the lease early, you need to leave. Otherwise, you're still bound by it.
Did they pay you rent for those 2 months that they held over, more or less?
Not in a timely manner. They eventually paid it
They
in
paid.
October 2021. Yes, Your Honor.
Okay.
Okay, thank you, counsel.
Your Honors, when Respondents' Counsel made their arguments, it's interesting what they didn't discuss. They didn't discuss the early termination provision, which is paragraph 2 of the amendment to the lease, and that's on 93 of the record. And to your point, Judge, that provision does not require that you vacate. That provision requires that all monies have to be paid up to the termination date. When they cite section 22 of the lease and section 17 of the lease, those are irrelevant to this.
So my concern is, so you obviously, he admits that you, at some point, you paid the rent up through the termination date, but then you stayed between the termination date and the vacate date. So those 3 months, April, May, June. So what happens to those 3 months? I mean, if you were supposed to terminate, weren't you supposed to be gone? Isn't that what terminate means? And what was the story for those 3 months is what I'm concerned about.
Understood, Your Honor. So first, those 3 months were eventually paid in October. The reason my client did not vacate on the termination date was because the landlord had an issue with regard to the condition of the premises. This was a unique lease in the sense that it required that initial installations were allowed to be kept and building standard things that my client put in were allowed to be kept. The landlord had an issue of that terminology. Quite frankly, there was some ambiguity as to that language. So my client, in order to appease them, stayed after to get rid of certain items that were in the property. So that's the only reason that they stayed over.
At bottom, like you say, paragraph 22 is not subsumed within paragraph 2. That determination and vacature are not combined. They're mutually exclusive. And the understanding, the way I read it is that although you terminate, you're still on the hook to vacate and clean out that premises after the termination date. So whatever is still in there, you got to go back in there and make it broom clean, and whatever cost it takes, you're going to have to bear those costs. And if you have to stay over 2, 3, 4 months, you got to pay me for it.
Yeah, and payment was made. But like I mentioned earlier, they are distinct, termination date and vacate date. Now, we had a dispute with the landlord regarding the condition of the property. As I mentioned, it wasn't so clear, but I think it's critical. The trial court didn't address any of these issues. Instead, they granted summary judgment. To the extent that there's $33,000 owed, that wasn't addressed by the trial court. To the extent that we needed to stay over past the termination date to fix certain things at the behest of the landlord, that wasn't addressed. So all these issues really...
Issues of fact that can't be...
Correct, Judge. Thank you.
Got it. Okay, thank you. Thank you both. The next case for argument is Cohen versus Gordon and Silver. I am recused from that case. So there will be 4 judges on the panel at this point. Thank you.
Okie dokie.
Good afternoon, Your Honors. I'm Neil Postriguez on behalf of the appellant. It is well settled that the decision whether to grant a stay pursuant to CPLR 2201 rests in the sound discretion of the court. The lower court, in a nearly identical 2201 application, filed just a month prior to the instant motion, granted Mr. Cohen's stay application, finding that the factors considered by New York courts, including avoiding inconsistent judgments and the potential waste of judicial resources, were present in this matter. Specifically, the court stated, it was very concerned about doing anything with
Counsel, how would a stay help you when your client took the fifth, pleaded the fifth in the civil case, correct?
That's correct.
In terms of discovery, what's going to happen? Because nothing's going to, I mean, discovery couldn't even go forward, or even there was discovery, he taking the fifth. So why would we stop this civil proceeding from going forward?
Understood, Your Honor. If the criminal case is allowed to move forward before the civil case, and if my client is indeed found to be not guilty, then we can make motions for post-note of issue discovery based on the fact that there's no prejudice to the respondents. We can also make an order to vacate the preclusion order in this case. What happened here is my client filed this case originally in July 29th, 2020. There were counterclaims filed in October 30, 2020, and he wasn't indicted until April 6, 2022, and then arraigned a week later on April 13th, 2022. By that time, before he was actually arraigned, plaintiff was required to file note of issue and to attend depositions. And
Counsel, didn't he bring this civil lawsuit with some kind of heads up that there was going to be a criminal prosecution?
I do not believe that he brought the civil lawsuit with a heads up. At some point within the litigation, there were rumblings. What happened is respondents, attorneys, partners of former partners of my client had an attorney present the district attorney with all of their files, just showing how connected these cases really are. But at the time of actually filing this case, my client believed he was wrongfully terminated and that respondents converted his shares and monies that were owed to him.
But the trial court, in this matter, believed that a stay was unnecessary, given the posture of this matter in the trial court. You had already filed, your client had already filed a note of issue. Your client had been deposed and basically taken the fifth in just about every question that was asked. Your client had been precluded from testifying at trial, in essence. So the court felt, what more is there? We can simply proceed with whatever we have to do in this case, because otherwise we're going to have to wait for years until the criminal trial is resolved.
Your Honor, I understand that, and when Judge Crane exercised her discretion in the first order to show cause, all of that was presented by Respondents' Counsel. I believe it's on the record, page 74. It goes into detail regarding the fact that the note of issue was already filed, the fact that depositions were already taken, the fact that there was a preclusion order, but the judge familiar with this case, still in her sound discretion, found that there was a need to stay it. I mean, the language is pretty strong in the first oral argument and in the transcript regarding her hesitation and the need for a stay. And what happened here really is that during, and you'll see in the transcript, during oral argument, I'm texting the criminal attorney to try and get a date certain for the filing of the motion to
So
dismiss.
your client's been deposed, right? And he didn't answer the questions put to him during deposition by taking the fifth, right?
He
And
didn't, yes.
right? And then there's a preclusion order that came down that my notes indicate that the preclusion order precluded him from offering testimony on any issue he refused to answer during his deposition. That wasn't appealed, so that's still a standing preclusion order. So why is it then, why would a stay of this, what would it do? At that point, he can't, there's nothing else for him to put forth.
Well, the stay would allow the trial to take place, and Your Honor, it's not years. There's actually an appearance in the trial part this Friday, the 19th. The case is progressing, and my understanding is that it should be tried by September of this year. Now, he may not be able to testify against things he didn't answer during his deposition by taking the Fifth Amendment, but if he is found to be innocent and not guilty at trial, certainly that's something that we can present in opposition to summary judgment motion showing going against the negative inference. And again, we can make a motion to vacate the preclusion order and for post note of issue discovery because of the lack of prejudice. I think summary judgment motion currently is scheduled for the end of this year and trial for the beginning.
It's not as if you're the defendant, you're the plaintiff. You're charting the course. You're suing because you're suing the former partners or the firm. So it's your case. So why is it that we want to stay this case? I mean, you know.
Because again, Your Honor, my client brought this case almost 2 years before he was indicted. The fact that defendants then presented to the DA all of their, quote unquote, evidence for them to be able to charge my client years later shouldn't rob him, one, of his right to prosecute, and two, there are also counterclaims. So now he has to defend against those.
All right, you'll have a couple of minutes on rebuttal. Thank you.
Thank you, Your Honor.
Good afternoon. May it please the court. Michael Dvorkin of Litchfield Cabo for the respondents. The question of which trial, which case goes to
So
trial.
why shouldn't we stay this trial?
Well, the question of which,
let's get right to the heart of it. Why shouldn't we stay this trial, right?
Your Honor, the question of which case goes to trial is really not, I'll submit, really an issue here because the issue, the order being appealed from specifically states that there was no reason why defendants' summary judgment motion shouldn't go forward. And so the judge ordered that plaintiff's motion for a stay is denied without prejudice to moving for a new stay after summary judgment has concluded. And if you read the court's decision and the argument on the record, the court, Judge Crane specifically stated she actually assumed that the criminal trial was going to happen first no matter what because her trial schedule was so backed up. She said, I'm not concerned with the trial. I want to know why the summary judgment motion can't go forward. And
Yeah, but you know what, the summary judgment motion, I mean, there's a preclusion order against the plaintiff, right? So that summary judgment motion, it's, unless you're not, it's hard to believe that you're not going to prevail on the summary judgment motion, right? Because he's not going to be able to respond to a lot of your arguments.
yes, yes. Well, and really that's
a real slam dunk. If you lose that one,
yes, I agree. And I would say that really what you're saying is what the plaintiff is calling prejudice is the fact that I don't think this summary judgment motion should go forward because I think I'm going to lose.
using the
That's
Fifth
not
Amendment
prejudice.
as a sword and a shield at the same time, right?
That's right. That's right. And when Judge Crane asked plaintiff's counsel to articulate why the summary judgment motion shouldn't go forward, plaintiff's counsel said, well, maybe we might possibly get the note of issue stricken and then he can appear for another deposition or he could put a
And
declaration
let's not
in.
forget, they filed a note of issue, right?
The plaintiff filed the note of
They
issue.
said everything's ready to go.
They moved the case forward, they filed the note of issue, and so they said that, and Judge Crane said, no, we already decided that because this was the second application for a stay. The first application for a stay was a motion for a stay, number one, and number two, to vacate the note of issue so that the criminal case could go forward and then he could appear for a deposition and answer questions. And Judge Crane said, no, I'm not vacating the note of issue. He can't appear for a deposition.
And in
The
fact,
preclusion-
didn't it was conditioned on moving to dismiss the criminal indictment? And that was
Yes.
like, it was only, when it came back before her on the order on appeal, she found out that that the motion wasn't even made yet, or if it were made, it was only parts of the indictment that was seeking to be dismissed, but the other parts were not. I mean, it wasn't full-fledged when she made it very clear when she granted the first stay, you're going to move to dismiss that indictment. I want to see where it goes.
Well, that's correct. But in addition, in that first order, where she conditionally granted a stay, Judge Crane also set a date for oral argument of the motion for summary judgment a month and a half later. And if you read the transcript of proceedings, Judge Crane, as it turned out incorrectly, assumed that the criminal case was coming to a head, it was going to be resolved, we can go forward with the summary judgment motion. That turned out not to be correct. But those two orders,
The motion was ultimately denied, correct, in criminal court?
yes.
No, the preclusion order, I don't have it in front of me. Isn't it just precluding her testimony, his testimony concerning the matters he didn't answer questions about?
Yes.
In other words, he could call in, and the reason I'm asking is he could call in a forensic accountant or someone else to testify about the records and why everything was totally kosher at the law firm. I mean, hypothetically. In other words, there's other ways to defend himself potentially in a motion for summary judgment using testimony that is not his own.
I'm sorry. Could you repeat that?
In other words, there's other ways for him to defend against a summary judgment motion involving other witnesses that are not the plaintiff.
Well, yes, I mean, whatever he chooses to do or not do to oppose a motion for summary judgment, it's not going to change whether it's done before the criminal case is concluded or after. Judge Crane asked plaintiff, why can't the motion for summary judgment go forward? What's going to be different? The plaintiff could not articulate a reason in oral argument. They didn't articulate a reason in their brief. They didn't articulate a reason in their reply brief, and plaintiff has not articulated a reason why that motion for summary judgment can't go forward today at oral argument. And the question of which case gets tried first, again, Judge Crane left that question open in her order. She specifically said the motion for a stay is denied without prejudice to renew it after summary judgment is decided. So the question today is, why can't that motion for summary judgment be decided?
Okay, thanks.
That's the question. Why can't the motion for summary judgment be decided?
It's not that it can't be decided, it shouldn't be decided. And that's the distinction. And again,
It's not going to dispose of the entire matter because,
well, it doesn't dispose of the damages, and Judge Crane in the transcript says it's going to be really difficult for this court to determine the damages. In the criminal court, would be more experienced and would be able to ascertain damages. And Judge Crane.
I don't know about damages in criminal court. Criminal court is guilty or not
Restitution.
guilty. It's called
Yeah, but it's
restitution, right?
the restitution, and they have the records that.
But as my colleague said, as Judge Moulton said, I mean, this is a summary judgment motion. I mean, you may be, your client may be precluded from pointing to anything to his deposition because of where he took the fifth, but he's not precluded from. Look, if they're moving for summary judgment, your simple task is to raise a factual issue, right? So you can put in everything you want in terms of other evidence, admissible evidence that can just raise a factual issue, simply raise a factual issue to warrant denial, unless you're going to cross-move for summary judgment to dismiss the case. I mean, that's it's not trial that we're at. We're at the motion, we're at a dispositive motion phase.
I understand that, and Judge Crane was aware of that in her first decision when she said, I'm waiting until after the criminal case is resolved because I don't know.
How long is that going to, how long is this going to last? I mean,
It's in the trial part on, in this Friday, and it's scheduled for trial, I believe, by September, the latest of this year. That's even before dates that Judge Crane has available for summary judgment, argument, and as well as trial. Well, it's not that this case is dragging along. It's not as if that 1 week extension was a stall tactic. It was an extension that was granted by the criminal court, and the decision date for that motion, it remained the same. There was really no prejudice or intent on the part of plaintiff, and that's how it's distinguishable from the cases relied on by defendant, where they found the action to be frivolous and sanctionable conduct. And another distinguishing factor between this case and the case relied on by respondent is in, I believe it's access. They took the Fifth Amendment to each of the allegations in the complaint, which the court found to be tantamount to a default in which they basically, the facts are alleged to be true. Here, my client denied all the allegations in the counterclaim. So there are distinctions between the cases relied on in respondents.
okay. Thank you,
Your
counsel.
Honor.
Thank you both. Next case up, Ponce versus the City of New York. I'm recused on this case. Justice Kapnick will be back in 1 second.
Okay, counsel for the appellant, you may begin. Good afternoon.
Good afternoon. May it please the court. My name is Jeffrey Bloomfield on behalf of the appellant. Your Honors, this court should reverse the lower court's granting of summary judgment as to 241-6 under Industrial Code 23-1.7D, as well as Labor Law Section 200. Turning first to Section 241 sub 6.
Well, wasn't the problem that the court found that this was not a walkway or a pathway, but was in an open area? And in reading the record, it does seem like it is in an open area and that it's distinct from some of our previous cases where we found it was a walkway. So how does this fit into that industrial code provision that you're trying, 1.7?
Okay, so looking at the
Facts of this
looking at the
case.
facts of this case, at the time of the accident, the appellant was utilizing a route that was located between two buildings, approximately 30 yards apart. He was proceeding from a direct pathway from the first building to the second building where he was getting rid of snow and ice, which he was instructed to do. He had been about 10 yards on this pathway when he slipped and fell on ice. Given the use of the pathway and the anticipated means of
Counsel, what
reversing,
evidence do we have that it was habitually used by workers?
there is no evidence of that in the record, as either for plaintiff or for the defendants on either side.
And didn't plaintiff himself testify during his deposition that the area where he fell was a large open area?
So he was
He used those words.
He was asked in the question if it was a large open area or if there was other equipment or other things nearby. He echoed the response saying it was large and open. However, if we look at this court's decision in Potenza v. the City of New York, in that case, it was very similar to this in that it was also an unpaved pathway that was outside, exterior, and in Potenza as well, the plaintiff had walked from one area to another, and
Yeah, but
in that one, the
Potenza,
court-
at least you had other witnesses, did you not? I mean, there were other employees of the defendants who said, yeah, we use that as a walkway.
correct. In that case, there were. In
You
this
don't have
case-
that here.
Correct. And they're not here either for the defense either. It is their burden as well to prove that this does not come under 241.6 1.7d. There was nothing in the record for them to prove, such as in Potenza, whether the location was a walked path that workers generally walked, whether the number of workers who used that path, how often they did. They could have easily put in affidavits or any testimony showing that this was not a walkway.
Do you have any photographs in the record showing a defined path or walkway? Are those in the record?
There are photographs, but because there was so much ice over this location, you cannot even see anything below it, whether there is a walkway, a pathway, or anything else. And
But you
Because the
did
reason why I asked that, because when I looked, I didn't see anything. That's why I wanted you to point.
that's correct, because there was so much snow and ice there. And he was going from one building directly to the other to remove ice from that building. It's our position that even if the record for plaintiff doesn't show that it was a walkway, it also doesn't for defendant. I want to turn also to my 200 point as well. Under Labor Law 200, obviously the condition has to be visible and apparent, as well as there being noticed. There's no question here. It was a thick sheet of ice and snow. It posed a slipping hazard. As to notice, defendant testified that there were multiple project managers and assistant project managers on the site daily, specifically that two of those project managers, Cassie and Betsy, got to work at 7:30 a.m. daily. Now, as to notice, the accident occurred at 9 a.m. So these project managers, their arrival at 7:30 a.m., that gave defendants more than enough time to discover the condition that the entire work site was covered with thick sheets of snow, which were impossible to miss. Defendants made a motion also for summary judgment on 200, and in their motion, there was no evidence whatsoever showing whether these two individuals were there on the day of the accident, and even more importantly, when they last inspected the area. There is nothing in there, and as such, defendants can't show prima facie that they lacked constructive notice of the defective condition. They could have produced testimony, affidavits. There is nothing in the record to make their prima facie as to 200. The 200 motion for defendants relies on speculation, and they can't satisfy their prima facie. Thank you.
Okay, let's hear from the respondents, and you'll have a couple minutes for rebuttal. Thank you.
Good afternoon, Your Honors. May it please the court, Mike Winter for Dasney. The lower court's decision should be affirmed. This plaintiff arrived at work at 7 a.m. on the date of his accident. He was instructed immediately to start removing snow and ice at the project site.
Instructed by his own supervisors or by your people? Or
By his supervisor.
By his supervisor that was employed by the same company?
He was employed by Jacobs.
So was it Jacobs that, the people that instructed him to start cleaning the ice and snow?
That's correct, yes. He was performing this task from the time he was instructed to do it up until the time of his accident, which occurred at 9 a.m.
Yeah, but it was two different ice clearings, right? So in the first job, he had to clear from a building or a structure.
That's right.
And that took a little while.
Yes.
And then there was evidence that Dasney supervisors would come to the site at 7:30 in the morning. And so is there an inference of constructive notice or actual notice that can arise from that?
No, that's not. I mean, Your Honor, I believe that argument is merely a red herring. I mean, as I pointed out in my brief, he's basically arguing that somebody might have been there, so somebody might have known. There's no art, there's no...
Well, I mean, the photos aren't great, but they do show a sheet of ice, so...
They do, but even putting that aside, they were aware of the icy condition on the site because he was instructed immediately when he got to work that morning to start removing snow and ice.
Right.
But was there any evidence that Dasney was not there at the time? I mean, there's testimony that they would usually arrive, but any testimony that they were not there at that time?
No, there's no testimony either way.
Either way.
And you don't have an affidavit from any of those two supervisors or managers to say, we were not there at the time?
No, we don't. But our position is that it's not necessary because he was instructed to remove the snow and ice immediately when he got into work. Even if they got to work at 7:30 that morning, he was instructed as soon as he got there.
Was he in charge of removing snow and ice from that open area where he sat?
No, I don't believe he was initially. I don't believe he was assigned to do it at that point. But the entire site was covered.
So he was, but he was working inside some of those open structures.
Yes.
That's where he was removing snow from, not from anywhere on the outside of the buildings.
No.
Such as this open area where he fell.
No, but there was just insufficient time to clear an entire construction.
But at least a path could have been cleared so that someone that needs to walk from one building to the other could walk along that cleared path. And this was not done.
No, but
And there's nothing in the record to show that anyone was instructed to do that.
no, not at that point. But he was instructed to clear one section of the project, and then clear another section of the project. And the bottom line is that DASNY and the entities on site at the time were aware of the icy condition.
DASNY was aware of the icing condition.
That I don't. DASNY was not responsible for removing the icy.
If they saw defective conditions, those managers, were they under a duty to notify someone and to try to get it resolved?
I believe that the project managers that the appellant referred to in his brief, I believe the testimony is that if they were on site and they observed it, they should have reported it. But the plaintiff hasn't established that they were on site.
And they have not established that they were not on site.
Correct.
Because you said there was no testimony about that either way. And your chief project manager testified that complaints about snow and ice could be directed to any number of people. I mean, it seems by looking at the pictures and listening and reading the testimony that anybody that was there saw the ice. I mean, it wasn't like a little piece of ice, it was covered with ice.
Right, the entire site was a sheet of ice. But just to emphasize, snow and ice removal were actively ongoing at the site from the time the plaintiff was instructed when he got there up until the time of his accident. It's a huge site. There's nothing more that they could possibly have done because they were actively removing the snow and ice at the time of the accident.
Okay,
Thank you.
let's hear from third-party defendants.
Good afternoon. May it please the court. My name is Pui-Chi Chang, and I represent the third-party defendants, Jacobs Project Management and ARC Electrical and Mechanical Corporation. Jacobs was the project manager. They were not involved with any ice or snow removal. So I want to correct that, what was previously said by other people prior when they were making statements to this court. So Jacobs had no responsibility to remove snow or ice from this site. They were
This
responsible.
construction manager could direct workers not to go to certain parts of the site, correct?
The construction manager, the construction manager, which is the project manager, is in charge of scheduling and making sure that the work at the site is moving along on a timely schedule. ARC, which is the plaintiff's employer, is the general contractor.
Right.
They were responsible for snow and ice removal, and that's what the plaintiff was hired to do.
I guess let me be more specific. Did your client or did Jacobs have any responsibility at all
No.
to let me finish the question, to tell workers to stop doing something if it was dangerous?
If they observe something, generally speaking, of course, they would tell someone to stop doing something that is dangerous. They wouldn't want anybody there to engage in any dangerous activities.
Well, wouldn't that potentially include walking on what appears to be, from all the testimony, a very, very icy area outside?
Well, that morning, my understanding from the record is that there were other people on site aside from the plaintiff, and they all managed to walk and maneuver this job site. The plaintiff was the only one who traversed into an area where he slipped and fell. And this was an open area, and there were no walkways. That is his testimony. And if you look at the record, page 310 and 311, he testified that there were no walkways, there were no pathways, because he had been at this job site. He's not a daily worker. He comes and goes as he is needed. And on the prior occasions that he had worked, he had been on the site, and there were no walkways and there were no pathways because this area was still under construction. They had just put up the exterior walls of the structure. They had not done any other work. So there were no designated walkways or pathways. So that is why under 241.6, there's no code violation, because there is no pathway and there is no walkway to remove any snow and ice from. And now, aside from the fact that Jacobs had no responsibility to remove snow and ice, neither did Dasney. They were an owner's rep at this construction site. And as an owner's rep, they were not responsible for snow and ice removal. Again, it was ARC Electrical and Mechanical that was responsible for the snow and ice removal. And they did have the equipment there. And that is exactly what the plaintiff was doing. He was going over to an area where salt was being kept to pick up some salt so that he can continue on to the next assignment of snow and ice removal at another point of the construction project. And I respectfully request that this court affirm the lower court's decision. Thank you.
Thank you. All right, counsel, you have 2 minutes.
Thank you, Your Honor. As Your Honor's correctly pointed out, Dasney did have a duty to report the snow and ice conditions. That was their responsibility. The plaintiff was not responsible for clearing snow and ice from the area where he fell. It was just
What time in the morning did he fall?
It was approximately 9 a.m.
So he had been there for a couple hours already.
He had been there. There's no testimony that the Dasney workers were not there, and they failed to produce any testimony of when this area was last inspected. They have to meet their prima facie, showing that they lack constructive notice. On this record, there is no evidence that they have proven that.
What about Jacobs? Did they also have a duty like Dasney to report the icy condition?
There is testimony that they actually might have had a responsibility to remove the icy condition. Dasney was the one who was responsible for reporting it. They didn't actually do it. They would report it to subcontractors and other people there at the site. The plaintiff himself, actually, in the record, this was his first time ever actually removing snow and ice. Obviously, he did it. He was tasked to that day. He did it in the building that he went to, and then they said, go do it at this other building, put salt on it because there was an inspector coming. Of course, they wanted to make sure everything was safe. He went through this path, and he fell. It had been there. They should have known about it, and there's no evidence that they've met their prima facie. Thank you.
Okay, thank you. Thank you all. The next case for argument is People versus Hernandez.
Good afternoon, Your Honors. May it please the court. Cara Labini for Mr. Hernandez. We are asking this court to reduce the almost $20,000 restitution order in this case because there is insufficient evidence of Mr. Rubio's losses that were attributed to the fire, and because Penal Law 6027 requires that the defendant be reasonably able to pay the restitution amount, and that was not considered below.
Well, I mean, I think it was considered because there was a lot of back and forth about the fact that Mr. Hernandez wanted to be an entrepreneur and was trying various businesses out and was not showing up for probation appointments scheduled by probation where he may have been able to get a job, a paying job rather than an entrepreneurial experience or opportunity, so that maybe he could make back the money to at least pay the restitution.
So you're referring to the 2022 hearing. First, he
Because
had a job.
there was a hearing, you made this application in the trial court, and there was a hearing and a decision on that. Yes, right.
Yes. So he was employed in 2 jobs that he got through probation. There was no evidence that these alternate jobs would have led to any more money for him, gainful employment that would have ensured him more money.
Any more money? He wasn't making any money, so
He was. He was employed at 2 jobs, Monday through Friday, 8 a.m. to 3 p.m. And he testified that he was unable to attend probation's appointments, or not appointments, but the programming to make him eligible for other jobs because he already had commitments at his current job. And he could not depart from the table that he was employed to be at during those times. Otherwise, he would lose the job that he currently had, which were allowing him to make ends meet and to pay the meager rent that he pays in a boiler room where he stays. As to the loan that he received...
Did he pay anything towards the restitution amount?
He did.
He did?
Yes.
How much?
I believe it was $150.
And then he expressed his recalcitrance to pay any more, did he not?
I'm sorry?
He said he wasn't going to pay anything more, didn't he?
No, what Your Honor might be referring to is page 43 of the transcript, where the defendant, Mr. Hernandez, said that he believed he wasn't obligated to pay, but then said, that's not really what I mean, let me rephrase that. I just believe that I shouldn't have to pay for something that Mr. Rubio never actually bought. So the $5,818 that were assessed on him for an air conditioning unit that was never installed and never purchased, he should not be required to. He was essentially making the same point that we make in our briefs, that he should not be able to.
I can get some of that argument about the refrigerator, but what about the other charges that for the labor to repair his office after the fire? What was not substantiated on those claims, on those?
Right. So the $4,500 the bill for $4,500 said labor for everything. Okay. Then there was a bill for $8,500 that included several line items, including air conditioning. So we can assume that those are the hard costs, right, of the repair work, as the other bill was for labor. So if that $8,500 included the actual air conditioning unit that was purchased, which the expert testified valued no more than $1,000,
Right.
then that order should be reduced by at least $1,000. And then there was also no evidence that there was no pre-existing damage to Mr. Rubio's store prior to the fire. So Mr. Rubio could have had damages that were repaired by the Riveras that Mr. Hernandez is now being forced to pay. And there was just no evidence as to any pre-existing damage that was in the store. So that's why the exhibits 1 and 2 are insufficient to make out a preponderance of the evidence.
How did you expect them to prove that? I mean, there was fire damage all over. They had to repair it. So what are you saying about damage before?
Well, they could have asked Mr. Rubio, was there, pre-existing damage that was repaired, or any updates made that weren't directly attributed to the fire? For example, let's say there's floor tiles. That was a line item that was on the bill for $8,500.
What was that?
Floor tiles.
Floor tiles.
Let's say there's floor tiles, and because of water damage, they needed regrouting. But if there were pre-existing damage to the floor tiles, like cracks, the Riveras might have thought, well, let's just repair the floor tiles too. That's just one example. And I think there are many other possibilities. It's just that the prosecution did not meet its burden in asking those questions.
I want to go back to the $13,000 with the receipts. Why do you take the position, or tell me, that Rubio's testimony, because it corroborated the receipts?
Why do I, sorry, say,
Yeah, I mean, didn't Rubio testify and that corroborated what was set forth in the exhibits, the receipts?
I think, frankly, the transcript of the hearing is an absolute mess. It's very difficult to understand what Mr. Rubio is saying was an actual expenditure. He says that he took out a loan for about, I'm not even sure actually, took out a loan and that he used it to pay electricity and bills, and he did not directly link it to the fire. And then he said, the way he testified was just incomprehensible. Like, I paid him 40, I paid him 45, and then I paid him the rest. And then I think there's a line that we quote in our briefs to that effect. It was just unintelligible. And I think part of that was because he was not a native English speaker and he was not afforded a translator, which would have been helpful.
Okay, let's hear from respondent, and you'll have a couple minutes to rebut. Thank you.
Good afternoon.
Counsel, if I may, can you take that up because?
Could he just state his name for
Oh,
the
I
record?
apologize, sorry.
Thank you.
May it please the court, Paul Anderson with the people. To pick off where we just left off. Yes, Your Honor. This was a hearing conducted, I think, 5 years after the fire was committed. This was a non-native English speaker. He's talking about the money he had to pay in cash to repair his own store. And yes, the testimony was difficult to understand, and I think that's why the court really tethered it to the documentary proof he had that he supported, and he was cross-examined thoroughly of there's no letterhead here, how do we even know this is from you? And if we look at the statute, CPL 400.30, it's all evidence that's relevant is admissible unless it's privileged. And so all of this goes to weight, and he was very much thoroughly cross-examined on all of these points. And so when we have here him saying, here's the receipts I got from the contractor years later. I've gathered them up. I even have the business card of the contractor to support this claim. And that's something that the Court of Appeals contemplated in Zizi Galakis, in that when you make the prima facie case, or the prosecution makes a prima facie case, it's on defense to rebut that. And defense clearly did. Defense called or subpoenaed a witness to attack one of the receipts. So the defense counsel could have looked at the business card. I think in the brief they claim it's the same person who testified at trial. Could have gone up and said, Mr. Jose Rivera, the contractor, can you walk me through these damages? What were the condition of the tiles before? And they didn't do that here. Instead, they just attacked the credibility of Mr. Rubio here, who owns this bodega that sustained heavy damage during a two-alarm fire that defendant set, and was proven beyond a reasonable doubt here. And so taken all together, looking at the receipts here, and this was over multiple days of this hearing in which there was adjournments and opportunities.
And the other thing is we have to keep in mind that we're not dealing with large-scale commercial establishments where everything is receipted and everything has a contract and everything. I mean, this is a small business, cash business, and this is an individual who sustained heavy losses. He's trying to get back his business, right? I mean, this is where the problem is, and he's doing the best he can in terms of putting forth what his losses are. And I mean, I'm just making the point that we're not dealing with multi-million-dollar corporations where you're going to have a receipt for everything, and everything is done by cash.
Exactly, Your Honor, and I think that's why when we consider that he testified credibly that he took out these two loans that amounted to $22,000 pre-interest. And we didn't even ask for the full amount of that because we'd understand that probably wouldn't match up exactly.
What about the refrigerator? Counsel mentioned that there was some reference to the refrigerator that was purchased within the context of the $8,500 receipt, but then there was some other references to a refrigerator in addition to that. So isn't there some double billing on that issue?
In regards to that, so the testimony was around at page 48 to 51. He's explaining that exhibit, that's the refrigeration invoice, and he explained that I got this. It's dated 2017, so a couple years after the repairs were done. He said, I went to my contractor, I asked him for all the document to prove, and the contractor gave him this invoice, and I will concede, then the people below conceded that that clearly wasn't the air conditioner that matched here. And I think the court relied on, used that as a demonstrative that tallied these all together. That so yes, I agree that the receipt for $8,500 has two-line and repair, AC, floor repair, ceiling repair, bathroom repair, basement repair. But I think it then, I guess, combined all together in terms of like one receipt dealt with more all the lines going from the air conditioner. I think you see that in the testimony. He's describing all the little steps that go in there over the course of the days, and then has this additional receipt that we below agreed that it probably wouldn't be the entire amount, but would then ask for $18,000. But then the court, I think, pegged the number to that, I think, $5,818, just to, I guess, split the difference of the losses that he had, or just to have the record support here. So that's why I think in the alternative, $18,000, what we originally requested, would be more than reasonable if the court is inclined to reduce. But to say that this reduce it further because the court didn't consider his inability to pay, that was not brought up in the original hearing at all. And as your honors were pointing out, he testified that he would not get a new job if it meant paying more. And that was a question that was in response to the hearing court. The court wanted to clarify, if he was hearing correctly, that you would rather continue doing the current job you have than making more money because and that's why you're not willing to pay this. And then further on, in I think 41, 42, he's saying, I don't want to pay. I never signed the paperwork because I refused that amount of restitution. And then again, he says, he never made the first payment because he did not sign the paperwork to do that payment. That's page 42.
Just going back to the air conditioner, because the quote was for $5,818, but that wasn't installed. And the actual value of the unit that was installed, your witness testified that ranged from $800 to $1,000, right?
There was testimony that it was an $800 to $1,000, and I think he was describing it as an old unit. But I agree. Yes, that's really the rub here, and I think there is a discrepancy between that $5,800 that's for a refrigerator. That's really not for a unit that was ever sold. I think maybe the contractor just gave him the wrong material. So if there is any error, I would agree that it would be over this $5,818. But he still sustained much more losses than that, and at least the $13,000 was supported by proof. And I think when we asked for the $18,000, that's reasonable. And I just asked that you affirm the conviction and the amount. Thank you. Or in the alternative, reduce it to 18.
Thank you.
I think the fact remains that you cannot get blood from a stone. Mr. Hernandez spent 2 years at Rikers. He was living in a homeless shelter at the time of sentencing. And he, at the time of the 2022 hearing, lived in a boiler room, which was essentially a single-room occupancy. This order, Judge Bruce's...
Sorry, were the 2 years at Rikers awaiting trial?
Yes.
Okay, thank you.
This order below, after the 2022 hearing, Justice Bruce's order, leaves Mr. Hernandez, Mr. Rubio, the courts, and probation in an impossible position because he is essentially, Mr. Hernandez, now on lifetime probation. He wants to pay restitution, he testified at the hearing, and he can afford to do so at $50 a month. That puts him on a payment schedule of being on probation and making payments for the next 32 years, at which point he will be 90. Check-ins with probation, court appointments in the meantime is just very difficult for all parties concerned, I think, and the limited resources that we all know that they have. And I would just ask that your honors craft a just sentence that adequately accounts for his ability to pay, as well as the losses that were substantiated by a preponderance of the evidence.
How old is he now, Mr. Rubio?
58.
And what did he do at the time that this crime was committed? What was it that he was doing? What did he do in his office?
Sure. So backing up a little bit, just to tell you a bit more about his professional background, he worked at a hotel in Coral Gables, Florida, prior to moving back to New York when his father was ill. His father operated and ran a dental business. I think it was fixing dentures. And dentists would bring in dentures to repair, and Mr. Hernandez then took over that business when his father passed away.
So he's got skills. He's got certain skills.
Yeah, I believe, yeah.
Mm-hmm. And he can't find a job doing something with the skills that he has?
I think because of his record, now it's very, very difficult to do so. I'm sure that if he could, he would love to. Mm-hmm. But I believe that's why probation has been so helpful in securing the jobs that he now has, and that he's sort of holding on to and risks losing if he were to apply for other jobs that probation might be able to offer him.
Okay. I think we understand. We'll take a look at the record again. Thank you.
Thank you, Your
Thank you
Honor.
both. The next case for argument is Kagan versus Medizadeh. Good afternoon.
May it please the court, David Douglas for the appellants. I would ask that the court consider, as it looks into the facts and law pertaining to this matter, that it keep in the forefront of its mind what fundamentally occurred here. My client, the trust, and the Medizadehs were 50-50 owners of the U.S. nonwovens business. The business was sold for over $200 million. There were $126 million in net proceeds, and the distribution of those proceeds therefore should have been, and the trust understood would be, divided essentially 50-50. Instead, the trust, that was a 50% owner.
You ended up with over a little over $17 million.
That's correct.
Right? And that's basically the argument, in a nutshell, is you were shortchanged.
Exactly.
Right.
We were, right, in a nutshell, we're 50% owner.
Right.
It should be split 50-50.
So how is it then, if you have all these agreements there that sort of put forth what was going on and it was signed by your client, one of your clients, how do you get over that, those arguments?
Right. Those agreements, the signature pages were provided to Charlene, who's one of the trustees, but she does not have authority to act on behalf of the trust. Only Ari had authority to act on behalf of the trust, and that's clear from the trust instrument. It's paragraph 11, subparagraph B.
But there was the argument that while that argument is made, there was also the counter-argument that was running the day-to-day or managing third parties or vendors, and it had nothing to do with this kind of transaction.
Yes, that argument was made, but I think if you look at the language of the trust instrument.
Yeah, I'm looking right at it. Full and sole authority to execute all legal and financial documents. That is, who was it? David that did that, right? Ari would have
Ari.
full and sole authority to execute all legal and financial documents on behalf of the trust, which shall be binding on all parties, right?
Right, but also that provision speaks in terms of all matters affecting the management, operation, or administration of the trust. And this seems to be that nothing could be more clearly involving the management, for instance, of the trust than a decision as to whether to sell a substantial portion of the trust assets. It's interest in U.S. non-law.
How do you align that with Section 6, which allows both trustees to conduct business on behalf of the trust?
Well, I believe that this provision trumps that provision, and even if that provision were to come into play, because what's important is in paragraph 11 it says, notwithstanding the appointment of co-trustees, that ours should have these powers. But if you look at some of the other provisions, as my adversary does, every one of those speaks in terms of the trustees collectively. It doesn't say that a trustee can sign on behalf of somebody. It says trustees. So under both the terms of the agreement and also under New York law, it would require both the trustees to do. It's also important.
Of course, the judge mainly relied on ratification, so we should probably focus our attention on that.
I'm sorry?
We should talk about ratification because of the behavior of both trustees after the deal was done.
Right. I think the court below focused on ratification.
Right.
Now, the court, I submit that under the law and under the facts erred substantially in finding that, because the ratification requires actual knowledge of the terms of a transaction before one can ratify.
No, but I'm sorry to interrupt you, counsel, but the actual knowledge could have been obtained by reading the deal documents.
Oh, let me turn first to Ari. Ari never saw the deal documents.
He knew the deal was going down.
He knew there was a deal, and I think the fundamental difference is that Ari knew and Charlene knew that there was the fact of a sale.
So as trustee, he's just allowed to say, I'm not going to look at the deal documents. I'm not going to look at anything having to do with the consummation of this very important transaction?
Well, he relied on the Medizadehs, who were fiduciaries. the trustees understood that they had a 50% interest.
But didn't they
These adults
also
were
have
handled-
pretty sophisticated attorneys? I mean, they didn't just go into this multi-million-dollar sale, by themselves. I mean, they had pretty seasoned attorneys representing them. Yet they still signed these documents and didn't seem to ask any questions.
No, there's nothing in the record indicating that there were sophisticated attorneys representing them. That they had
Kirkland and
outside
Ellis and Reed
counsel.
Smith are not sophisticated attorneys? I
No,
think
no,
they would disagree with that comment.
No. In the transaction, clearly sophisticated attorneys handling but Visa does have sophisticated counsel, and WinPoint, the purchaser, did. The trust did not.
Your clients had no attorneys representing them at all?
No, there's nothing in the record indicating that they were represented. They are not. There's nothing in the record indicating that they're sophisticated business people. This was a family trust. Ari and Charlene are
We're
brother.
not talking
sister.
about them, we're talking about they were smart enough running this big trust to get attorneys. Are you saying these attorneys weren't involved at that stage of who prepared these sale documents?
The documents are prepared by the Medicida's attorneys, who are sophisticated attorneys, and by the purchaser, WinPoint's attorneys, who are sophisticated attorneys. There's no question about it. There's I believe, I forget the exact number, 15 or 18 different transactional documents with various entities set up. It's a very sophisticated transaction. But my clients were not involved in that in any way. They weren't involved in negotiation. They did not know the terms. They could not have ratified it.
But they did have, did your clients, at least I'm looking at this record here, the MIPA, that's the key document, right? Did your clients have that document?
No.
They never got that document?
The signature page of that document was provided to Charlene, was never provided at all to Ari. Charlene, and the first time my clients received the full MIPA was in discovery once this lawsuit had started.
So you're saying that she signed this document without looking at, just signed a signature page without looking at this whole document and just decided to do that on her own, thought that was a good idea?
That is what she did. I
That's what
can't
she
say what her thought process was, but that is what she did, which I think is evidence in terms of you talking about being represented by sophisticated counsel being involved. That's not the case here.
I just want to go back because, my notes indicate that counsel had conceded at oral argument that Ari knew the assets of the company were being sold, and that he also knew that the transaction was being negotiated and that it had been entered into. So how do we deal with that?
No, what the sequence is that Ari knew that the sale was being considered. About a month after the closing, he came to learn that there had been a closing, and he sent this text, which the court below relied upon, what we call the Mazel Tov text.
Yes,
We read that, yes.
I think it's Chinese for congratulations.
Right.
Got it.
Right, and he was congratulating Shervin Medizada on the sale. He did not know the terms of the sale. He didn't even know the sales price. It wasn't until the spring, as the record reflects, that he first learned from an outside source what the purchase price was, and the Medizadas had taken as supposed goodwill $84 million. That was learned in spring of 2020. The transaction closed in August of 2019.
Okay, let's hear from your adversary, and then we'll come back to you for a few minutes. Thank you. Good afternoon.
Good afternoon, Your Honors. May it please the Court, Y. David Scharf of Morrison Cohn for the respondents.
So
time.
to your knowledge, they had no attorneys they were relying on your clients and not on any attorneys during this end of the sale process?
I don't want to split hairs with your question, Your Honor, but the record doesn't show that they had counsel. The record also doesn't show that they were relying on our clients in any way, shape, or form. The sellers in totality were represented by Kirkland and Ellis. There was no separate representation that the record shows that the Mehezidas were represented by somebody else. There's no separate, there's no.
And why would they? They would be they're all on the same side. So
They're
they have
all
one
on the
attorney.
same side, Your Honor.
Right.
And 4 times at oral argument, Ari and Charlene's counsel admitted that they knew the transaction was being negotiated and it was being entered into. What the court below had before it was a group of documentation. I think there were 7 or 8 documents that were necessary for this transaction, and they fell into certain different groups. Some of them were documents where there was no provision for any particular trustee to sign the document. Yet when the document came back signed from the trust, it was signed by Charlene. It could have been signed by anyone else. There were some documents that were signed by Charlene when they were sent to her, where the evidence showed that she had full and complete information. And most importantly, the contribution agreement. The contribution agreement, which is a document we know that they got, it's found at page 346 of the record. She acknowledges that she is the one that has the authority to sign. It is the document that spells out that there is a pre-transaction and restructuring that is going on. It makes reference to the MIPA. It makes reference to a document that we know Charlene signed and has literally a comic book description of exactly how this transaction is going to work.
And the MIPA sets out exactly how much the deal was.
Exactly, Your Honor, and it sets it right out on the front page and it says, if you don't want to read all of the 60, 70 pages, look at Exhibit A, because right on the front in the whereas clause it says, if you want to see how this works, because it's a complicated private equity transaction, look at the pictures in Exhibit A. And the pictures in Exhibit A make very clear at step 3 that the Mejizada family is going to be separately contributing something that it has. It's on page 1292 of the record. And it shows in step 3B, Mejizada family is contributing to Seller LLC its personal goodwill. And there is no line going from the Kagan Trust showing that the Kagans were contributing anything. And if you look down at the bottom, it talks about exactly how the funds flow was going to work with respect to that and the money that was going to be going and how it was going to be.
Why did they have this enormous amount of goodwill, your clients, and their clients did not?
Because as the complaint acknowledges, my clients worked in the business. My clients were signing a 5-year non-compete. My clients were the ones that were being paid.
You were doing the day-to-day work
They
of
were
their
doing
business.
the day-to-day. The trust was a silent investor, and with the exception of the grantor of the trust, Mr. Kagan himself. Let's remember, we see his name all over the documents.
Marvin, was that? Marvin
That's
was the
correct.
father?
Marvin Kagan, he's the grantor of the trust, but he's also a member of the board of directors. So this notion that there's been a victimization of the trust, when the grantor of the trust, who has the power to remove the trustees at any given point in time, claims to be the manager of the trust and documents that are put before the court. He is signing off from the corporate perspective everything that is going on. He is one of the providers of the documents to the trusts. He's bringing back documents that are signed by the trust. The trust instrument itself makes clear that somebody dealing with the trust, the Mejizadas, don't have to inquire into the authority of the people who are representing that they are part of the trust. And that very trust instrument by itself says that when you're dealing with a sale and a disposition of the assets, any of the trustees, because the language trustees has a provision in it that said it could be dealt with plural or singular as it relates to the use of the word trustees.
But the amount of the goodwill was much larger than the amount of the sale of the whole company, wasn't it?
It was not, Your Honor, because what the company had to pay off was all of the debts. So you're looking at a net number of $17 million, not an inconsequential amount by any, but that $17 million was split 50-50 between Mejizada and the trust, After all of the expenses, there was senior debt, there was accounts payable that needed to be paid off. This was a transaction, and let's remember also, if you look at the structure, why was it structured? There were many assets, including very valuable real estate and another valuable business that were actually retained for the benefit of all of the shareholders. This was a
Retained by whom?
by the Mehezidas and the Kagans, by the trusts and the Kagans.
So you still co-own things?
We still co-own things together, Your Honor. So what we have here is, and if I recognize my light, if I make just...
If we keep asking you, you keep answering.
Thank you.
We'll let you know when you have to step.
Thank you. If we look at this in totality, there was a sale of some of the assets in a complicated transaction. Everybody on the Kagan side knew what was going on. All the documents were being signed and signed off by people on the Kagan side of the family. They got their rightful share. They knew the transaction required signature. Justice Schechter got it 100% right when she said, you can't sign documents and then say, I don't know what it said. And that's the incongruity in their complaint. If they're claiming lack of authority, then they can't claim, I like the transaction, but I want more. If they're claiming there was no authority, then they need to blow up the transaction, give the money, and that's why, as a matter of
And there was no claim for rescission of this.
That's correct. And as a consequence of that, the complaint in and of itself, the issues that they're claiming are the predicate for the wrongful conduct is disconnected with the claims that they're seeking and therefore ratification as a matter of law.
I don't think that these little pictures are the easiest things to figure out. A lot of lines and circles.
It's like a flow chart that I got.
Well, in any event, okay, we'll take a further look. Thank you. We're
Venn
gonna hear
diagram.
from the appellant.
Yes.
So, I have a question that now that we've got this legal representation down packed, that the Kirkland and Ellis represent the sellers as a whole collectively, right? Both plaintiff and defendants here. Did you ever bother to get, in my mind now, thinking about that, did you ever bother to get an affirmation from an attorney who was on the deal to say the plaintiffs never got anything other than a signature page? Because that would be very productive to me in a sense of enlightening that your claim is that my clients, all they got was a signature page and they signed it and that was it. But if you got an attorney that says, no, they didn't get anything, all they got was a signature page, that's actually correct. That would be very telling.
Well, what's in the record is only the signatures page.
Uh,
You're pressing this case. There's a motion to dismiss, so at that point, an affirmation from the transaction attorney would be very helpful, don't you think?
Well, what we have the emails.
No, you're missing my point. The critical point is who's the person on the deal that would know whether or not your clients got the deal, got the agreement or not?
No, actually, that's the answer. I was about to answer that.
Okay.
Shervin Medizada is the person who, it wasn't the attorney sending the deal documents to my clients. Shervin Medizada is the one who sent them, and in the record are the emails of him sending just the signature pages for most of the documents, including the MIPA. Now, Mr. Scharf waved around.
He's the attorney. He's from Kirkland and Ellis, the person you just showed.
No, he's the
Yeah.
He's the
You're still not answering my question. Why didn't you get an affirmation from Kirkland, the transactional counsel?
We had no dealings with the
Okay, I got my answer. Thank you.
Yeah. I want to point out, Mr. Scharf waved around Exhibit A to the MIPA. We never received Exhibit A to the MIPA until discovery in this action. So, that's part of the problem. If we had Exhibit A, which spells out where the proceeds are going, then my clients would have known, wait a second, something's wrong with this deal. He also
But you're saying you didn't have anything except signature pages? You didn't have any of the content of the...
I believe there were 2 or 3 documents in which there were short documents that there may have been other like pages 1 and 2 in addition to the signature page. But all the other ones, it was just the signature page. And Mr. Scharf also used the word reliance. There's a fiduciary, and this is crucial, there's a fiduciary relationship here. My clients were relying
There's no question about the fiduciary relationship. The question is that if your client signed off on a document without reading it, or just signed off on the document whether or not read it or not, you're bound by that. There's case law that says you're bound by that. You're stuck with it. That's the bottom line. You can't go back and say, oops, I shouldn't have signed it.
there's two answers to that. One is that the person who signed it did not have the authority to sign it, and the respondents knew that Charlene didn't have the authority. They can talk about Marvin Kagan all they want. Marvin Kagan can't speak for the trust either. Additionally, there is case law in our brief speaking about where there's a fiduciary duty. There is no duty of inquiry on the part of the person to whom the fiduciary duty is owed. And I'll refer to our brief. Yeah, I don't have the names of the cases, but this is at the moment. I can thumb through my notes here. Yeah, if you look at the Birnbaum case, the Global Minerals case, Frame, Maynard, Anderson, and Nuss versus Sabad cases, I think that those will stand for the proposition that where there's an affirmative duty of a fiduciary to the person to whom the duty is owed, there's no duty of inquiry. And that the court erred in that regard too. We didn't have a duty to say, wait, are you cheating us? They had to, or are you dividing this in a way?
I think we have the main points here. We will go back and look at all these documents a little further, and thank you both very much.
Thank you. Thank you.
The next case is South Street Seaport versus Landmarks Preservation. Oh, is that right? Yes.
Good afternoon, Your Honors. Chase Mechanic for the Commission and the City. The certificate of appropriateness for 250 Water Street went above and beyond the requirements of a rational basis. It supplied copious reasons.
Why is it then you've turned down back in the 80s at least 3, maybe 4, development projects? It's the same lot, same area. Nothing's changed. So why did we go ahead and approve this one?
A few answers, Your Honor. It is the same lot, but it's not true that nothing has changed. The border itself changed in 1989 to include the block directly north of the building. And within that lot, there was a modern addition that was also done, again, after that border change.
Not that Manhattan high-rise, is it? Are you talking, no, that's further, that's too
No,
far
it's
north.
the Peckslip School, which has been referenced within the certificate.
Well, that used to be the
Post office.
Post office.
Yes.
Correct.
So that was a difference referenced within the certificate of appropriateness and elsewhere within the record. And I think this is the key point on the field issue. There needs to be a rather tight, or even I would say extremely tight degree of factual overlap between the comparator cases in order for field to be at issue. In field itself, the court said that the comparator cases involved indistinguishable facts.
Well, I think one of the things is that, back in the 80s versus 2020s now that we're in, things are very different in terms of what is put out there in terms of this virtual reality that we see and how we can see the actual construction of a building before it even goes up.
That is exactly.
And what I thought was very unique, and I know it's not in the record, but I know they didn't have the ability to have the shades of brick and however you want to do the facade, the setback in terms of how you want to design it so that from the street level sight lines, you're not going to be really seeing the high rise, but you're just going to see the 5-story. Don't ask me how I know this, I'm not an architect. But in terms of how you want to manage the historical vision, it looks exactly like that, right?
Your Honor, I do think it is an appropriate subject for judicial notice that in the early to mid-1980s, they didn't have the ability to have these photo montages and sophisticated computer renderings and virtual walkthroughs that the Commission benefited from in this case. And at page 75, 66 to 67 of the record, Chair Carroll noted that explicitly referenced the prior denials, noted that they were different, and then noted that the available technologies here provided what she called, yes, Your Honor.
I was going to say, the problem with all this is that this whole notion in the record here of this quid pro quo, that everything was just approved because of the Seaport Museum and trying to keep it survival, so infusing more funds to it. I mean, that's where a lot of this tension's coming from here, right?
Your Honor, a few things to note about that. Perhaps the most important thing to note is that in footnote 16 of the petitioner's brief, they repudiate the notion that under clocks, courts are any longer allowed to impeach the subjective thought processes of the commissioners when it comes to a certificate of appropriateness. Or at least there would need to be evidence more compelling.
Would it be a violation of lawful procedure under Article 78 to conjoin the two applications as they were done here? Because it did seem like Judge Engoron noted that from the very beginning, the two applications were conjoined and considered together.
Your Honor, there is no lawful procedure that the petitioners have identified that was violated. No rule, no statute, no regulation, no duty or other legal norm, and that is really essential. I would point to the Citizens Emergency Commission v. Tierney case, which we cited in our brief, that had a little bit of a different fact pattern, but the point remains in that case. There was a similar claim, and the idea was, if they haven't identified an actual statutory rule that was violated, then that's the end of the matter. They haven't cited a single case annulling any agency determination based on improper jointer. We cited 4 cases in our reply brief holding that that kind of argument would not be a basis for setting aside an agency action, including the Reisner case, which is one of the cases they cited in their brief.
What about the ex parte communications between the commission and the developers?
Similar answer, Your Honor. There is no statute or rule or other duty that is violated or any lawful procedure that is violated by engaging in these ex parte communications. In matter of Landmark West v. Tierney, this court held that those kinds of communications with an administrative, non-adjudicative body like the commission are fine. Their argument is I suppose, that the frequency of the communications was a problem. Again, there's no legal rule that they've identified which is violated, and to the contrary, the affidavit of Director Harala establishes that those kinds of communications are not only customary but desirable because they help the applicant refine their proposal and develop something which is reasonably capable of approval. And if the court has no further questions, I'll yield to my co-appellant. Thank you.
Okay, thank you.
Janice McAvoy from Fried Frank on behalf of the respondents appellants, the owner. Going directly to the issue of the quid pro quo, and I think it's important to step back and say, what is an improper quid pro quo? And the court below relied on City of New York versus 17 Vista Associates. In that case, the city had already determined that a building was not an SRO, but they didn't tell the owner that. Instead, they said to the owner, put $1.5 million in this fund for homeless, and we will issue this determination that it's not an SRO. Very unsurprisingly, the Court of Appeals held that that was void as against public policy. The city was already required to make a determination on the merits with or without a payment, and it was improper for them to demand a payment. Nothing like that happened here. Here, the Landmarks Commission was tasked with determining whether the aesthetic and architectural features of this project were appropriate for the historical district. And the record as a whole, and in particular, the specific findings in the COA demonstrate that. After 15...
Counsel, it's finally sinking in. Are you saying that the whole Seaport Museum concept there, that's still in flux? That's not, there's no agreement or anything. That was just a concept that was being discussed, right?
No, absolutely not, Your Honor. It clearly was related in that in order to build the project, the owner needed to buy air rights from the Pier 17.
Right.
The city determined, EDC determined, that the proceeds from that would be used to fund the museum as an endowment. Now, if the Landmarks Commission were only concerned with the affordable housing, the endowment for the museum, they didn't do a very good job because they made significant changes to this project. They reduced the height by 120 feet.
Yeah, it went from 38 floors to 27 floors.
Exactly. It got much smaller, meaning fewer air rights purchased, meaning $10 million less in funding to the museum, meaning fewer affordable housing units. If all the Landmarks Commission cared about, they would have approved that first tall tower. They did not. Instead, they went back twice to the owner. They said, we don't like that street wall. We want it to be differentiated like the rest
We
of.
need a setback going
We
to the
need a
north.
setback. We don't like those two tall modern towers. We want a single bar. And after all of those changes, which by the way, reduced the funding to the museum, reduced the affordable housing, and after that virtual reality walkthrough, which the commissioners, every single one of them commented on how you really got to see now how this building was going to fit within the context of the historical district. And instead of, my office is just a few blocks away, so I walk by it constantly, instead of walking by an ugly surface parking lot that has graced that site for 50 years, you'll instead be walking by a beautiful street wall that will match the surrounding area. And to the back will be a single bar that, because of changes both in the addition to the district to the north, the Peck School, will blend in seamlessly. There were other changes in the district in the 40 years since they had last considered projects, which the sites are, to the record, are in our briefs, but it's really important to look at those different designs. There was one curved monolithic tower that looked like it belonged, midtown and not downtown. This is a very different project. And instead of that vacant parking lot, you now have a design that matches the fabric of the district. You also asked about the meetings. Why were the meetings held at the same time? You have to also remember, this was during lockdown. All of the participants, all the people who wanted to speak were participating by Zoom. People wanted to speak on both of these projects, which were located 2 blocks from each other within the same historical district. And in order for the convenience of the architect who was testifying on both, for the convenience of the commissioners
Was
who were
that the
hearing both,
decision of, did the commission make that decision? Who made the decision that they
The
would have these
request
two
was-
together?
the request was made by the owner, and the commission decided to set their calendar. They have that discretion to set their calendar, and they did it. And it enabled participants who wanted to speak on both by Zoom be able to do that, and it made sense.
If I
respect
may,
to the
now I know that there was discussion regarding the benefits to the museum and also affordable housing, but the chair repeatedly cautioned, right, that those factors could not be considered in the determination.
Exactly right. Those considerations, while laudable, are not factors that we can consider. She said that repeatedly. The judge dismissed that as mere window dressing. She said it repeatedly. And of course, it made sense that commentators would make these comments. They also pointed to some of the isolated comments of some of the commissioners talking about how they do refer to the economic vitality that this would bring, but they're talking about the economic vitality to the seaport as a whole. You have to look at those comments in context. They're not focusing on the museum. They're not focusing on affordable housing. Economic vitality to the district as a whole, which in the statute, in section 25-301B of the Landmarks Law, is one of the purposes of creating a historic district, and therefore an appropriate consideration for the commissioners to consider.
What about the statements by the court in its decision regarding basically a meeting with the developer and doing a mock hearing and trying to help, according to the decision, trying to help the developer find political cover for the approval of this project?
I'll address both of them because they are separate. The first issue is, yes, there were multiple meetings. And first of all, as counsel pointed out, there's no rule, no law, no regulation that says that Landmark shouldn't be meeting with owners. And in fact, they always do.
It's what they're supposed to do. It's laudable. They're not a roadblock. They're supposed to meet with developers to discuss the design so that the owner can build a project that meets Landmark's approval. And the uncontroverted evidence from the current LPC General Counsel Silberman in the record at 8206, from a former Landmark staffer, Quaisbarth, at 8271, from a former General Counsel of Landmarks at 8296, all of them testified. These are routine, normal meetings. This is not an adjudicatory body. This is not, there's nothing wrong with ex parte. They don't meet with other people because they're not the ones proposing a new design to a building or a new project. They meet with the proponent of the project to work with that proponent, build something, design something that fits within this historical district. And that's what they did. Those meetings are customary. The practice meetings happen all the time. The political cover, a phrase that appears twice in the judge's opinion, but only appears once in the entire record, is in an internal Hughes PowerPoint that was not provided by Hughes to the Landmarks Commission, but was provided by petitioners. They sent it to Landmarks. No evidence that Landmarks ever saw it or read it, but critically, it's not focused on Landmarks. This project also needed zoning approvals that needed to be approved by the elected officials of City Council. That memo, that one phrase in that PowerPoint was focused on political cover for the elected officials to approve the zoning change. Nothing whatsoever to do with Landmarks. Meetings, which are routine, they were extensive here because this is an extensive project in an important area. Absolutely nothing, nothing controversial or insidious about them at all.
I just want to go back to the political cover because I was under the impression that there was also some type of internal memo saying that really had to deal with strategies to engage community involvement, I should say community engagement because of the controversy. So it really had nothing to do with the commission, but really addressing the community.
Exactly, Your Honor.
Okay, thank you.
Thank you.
Good afternoon.
Good afternoon. May it please the court. Excuse me. Reed Super for the petitioner respondents.
There should be some water there. I think that's, just be careful how you pour it. I've seen it spill, that's why I say that.
Thank you very much, Your Honor, and thank you also for granting a preference and hearing this argument so quickly. I'd like to respond to something that the developer's lawyer just said, that practice hearings occur all the time. There is absolutely nothing in the record that says that. Both appellants put in affidavits. They said meetings happen, we meet. Nobody ever said that practice hearings have ever happened before. This was a
Is there any violation of any rule or regulation that that you're aware of for the people to have these meetings?
Well, two things, Your Honor. First of all, there's an email in the record from the preservation director that said to the developer's lawyer, I don't want to meet every other week because that would make me and other senior staff appear overly involved. So he's admitting that there's limits. And if he doesn't want to appear overly involved, that's an admission that he should not be overly involved. But that's just the meetings. And here there were 50 meetings with the developer, 40 meetings with other city officials, the city officials that they made the deal with for the museum funding. But let me go to the question about whether there needs to be a codified rule that was broken, and there certainly does not need to be. The quid pro quo argument, the museum funding argument, what Justice Engoron said is it's an abuse of discretion. We categorized it as violation of lawful procedure.
You know, but the response to that was that, you know, if that were the case, that it was a pure quid pro quo, Landmarks would not have insisted on reducing the size of the project, which then concomitantly reduces the amount of money that the Seaport Museum and the Historic District would get. I mean, that was sort of like, it's self-defeating. So how do you respond to that?
Well, Your Honor, towards the end, they reduced the building.
Yeah, they went from 38 to 27. That's a huge drop. That's
Right,
11
and then the architect said, the reduction is calibrated, we've reduced it, but this now is calibrated at a level that will preserve the community benefits.
Right, so does
But any lower, they're gone, is what he said.
Right, so, but does that reduce the amount of funding? Because the funding is based on the size of the project. So didn't that happen? Did the funding go down, or the amount of monies that was going to
It
be?
went down. Your Honor, I think that
Went down substantially, I would think.
went from 50 million to 40 million. Yep.
Well, $10 million is not chump change.
Your Honor, there's an important distinction here. That there are, of the 11 commissioners, 10 of them are volunteers. They show up, they vote, they do nothing else. What we have said consistently through our briefs is that it was the chair, the one full-time paid employee who was appointed by the mayor, and the senior staff, that they were the ones that joined the hearing. The volunteer commissioners who ended up voting were put in a horrible position by the fact that the hearings were joined. They were told over and over again, 9 hours on the first day, 9 hours in the second hearing, over 800 times the word museum came up. They were told, before there was even a limiting instruction, they were told, please save the museum. If you do not approve this tower, the museum will not survive, which is exactly what was in the...
But it's
told them
unlike...
that?
Oh, I'm sorry.
I'm sorry. Who told them that please save the museum?
And we quoted as much as we could in the brief, Your Honor, but that was told by the applicant, by the museum, by the city officials that came, by other museum officials, by
So you're saying the people that they testified, and this is what they said during the testimony that the commissioners heard?
Well, first it was the presentation. First it was the presentation from the developer and from museum people. All of them said the museum is in dire. I mean, it's a bit apocryphal, but they said the museum will die. The seaport will. The tall ships will be gone. If you please save the seaport, if you do not approve this, the link was there. This came from, and there was a question from Justice Kennedy about the October 2019 strategic plan from the developer. It's page 331. This was not some sort of community engagement. On the page before 330, the Landmarks Commission is mentioned. On 334, the Landmarks Commission is mentioned. It said 250 Water Street. This is, by the way, a strategic plan of the developer to its investors and shareholders. It laid out in black and white, here is our strategy. It said challenges, height and building very controversial. Emphasize linkage of air rights transfer to Seaport Museum's survival. And then lo and behold, the museum and the tower application were combined. Combined, mind you, 3 months before the applications were filed, after all those meetings. And then...
So, counsel, let me ask you a question. You know, you're focusing on the fact that Landmarks, at least the commissioners or parts of the staff there, were in communication with the developer in terms of how to move this project along and how to get this approval. Has that never been done at all by Landmarks on other prior projects?
I'm sure they meet if they're abandoning their statutory duty and helping either the developer or the mayor get a priority project that's inconveniently
You
located.
didn't answer my question. My question is very simple. Have they not done this in the past? I mean, that would be very good in terms of my mind that, Judge, they've never, ever done this ever. This is the first time that they actually engage with the developer to move this project along.
Well, they've had meetings, but this has not been done. And you know how you know, Your Honor? The amicus, listen to the Historic Districts Council and the former commissioner. They're not interested only in South Street Seaport District. They're interested in all 149 districts across the city and the integrity of the commission. And that's what they wrote to the court in their amicus brief. This goes way above.
But I didn't see them saying that this was out of the ordinary in terms of having these discussions and these back and forths.
They absolutely said that. Your Honor, they can meet. It's not ex parte. No, they said that this crossed the line, that this went way over the line, the number of meetings. And it's not just the meetings, but it's that the meetings facilitated exactly what the developer said in the strategic plan. Link the tower with the museum survival.
So it's a combination is what you're saying, is the problem that the focus of your concern, or a big focus.
Yes, Your Honor. The entire museum project was a fantasy. The museum couldn't build the building. It couldn't even start fundraising for the building. The entire project was, the developer paid the architect, their own architects, to design an annex for the museum. Their lawyer submitted the two applications together. It was admitted throughout the hearing.
But you know, the thing is that you can't, back in the 80s when those projects were not approved and did not go forward, you can't use 40 years ago projects and say they're the exact same as today, so that, you know, what they did 40 years ago, they shouldn't be able to do it now. I mean, that's one of the arguments, right? That they're doing something that they didn't allow themselves to do 40 years ago.
You're talking about the field doctrine, of course, and agencies can change direction. But what they have to first do is acknowledge what they did in the past and explain why they're changing directions. Nowhere in the COA are the 3 denials on the same lot of buildings that were denied. Those buildings were denied in the 80s because, as the commission was very clear then, it would disrupt the homogeneous scale of the seaport. Those buildings would relate more to the apartment buildings outside the district and the office buildings outside than the buildings in the district, and destroy the clean line. Those weren't even acknowledged.
Yeah, but the virtual designs now, I mean, I'm just amazed and marveled at what you can produce in terms of what it's going to look like. That's a big deal that they didn't have in the 80s. They couldn't visualize, other than on a piece of paper, what it's going to look like. Now it's like, it's there. It just comes out of nowhere, and there it is.
I'm sorry, Your Honor. But that doesn't take field off the table. If they want to say...
I didn't say take it off the table. There's a nuance to field now, right? Because field didn't have this kind of virtual reality that we're all in.
Well, Your Honor, I wouldn't say it's a nuance to field. Field says that in administrative proceedings, as well as judicial, cases with like antecedents should produce like consequences to serve the appearance of justice and stability. What they need.
Exactly. I'm not disagreeing with you. Okay. But in terms of technology, we now have AI. It's called artificial intelligence. Things are different now. That you can't. Field is for a press. It makes its statement, but that has to also, you know, it's flexible in terms of what we have now, what is presented before Landmarks or any other agency in terms of what they've done in the past and what they can do now. I got your argument. Thank you.
Okay, thank you. I see my red light is on. Can I close very briefly? Two sentences. Your Honors, reversing on this record would send a clear signal to the Landmarks Commission, City Hall, and landowners in the city's 149 historic districts that anything goes, that allowing a contingent financial transaction or any other impermissible considerations to dominate a landmarks proceeding, to be the primary message delivered to the volunteer commissioners, so long as the chair gives a limiting instruction, so long as they don't mention it in the COA, and that the LPC can now function as an arm of City Hall to usher controversial applications through approval whenever a favored project is inconveniently located in a historic district. This court should not do that. This court should affirm the decision below to uphold the Commission's statutory obligations to be independent from City Hall and to faithfully implement the landmarks law. Thank you.
Thank you. Thank you, counsel.
Four very, very quick points, Your Honors. First, the petitioners fault the Commission for not explicitly mentioning the 1980s denials in the C of A, but cases like Stahl and Rivera holds that for field, we look to the entire record to determine whether the precedents have been addressed. Second, there was a question by Justice Owing about whether there's any sort of precedent here. The counsel for the developer did submit an affidavit where she remarked that the proposal to have reserved times for meetings with the commission actually was based on something that happened in a previous engagement or a previous case with the commission. That's in the record. On a related point, third, the email from Director Harala, that has been mischaracterized. What Director Harala said was he, a senior staffer within the commission, would not participate. Other commission staff would participate. He would participate as the case got closer to filing, and that's what happens. That email was in July, and what the record shows, and petitioners concede, in late September and October, as it got closer to filing, he began to participate again. So there's no there. And last, the petitioners point out that during the presentations, there was linkage between the museum and 250 Water Street by members of the public, by the museum, by the applicant. But notice what they're not claiming. They're not claiming that any of the commissioners themselves said that that would be a basis to approve the building, and the COA refutes it. We ask this court to reverse. Thank you.
Thank you.
Just a few quick points on some of those same issues. But one thing that I wanted to, thankfully, Mr. Super reminded me, there's something in this Article 78 that you almost never have. Thousands and thousands and thousands of pages of emails. The petitioners did FOIL requests. The judge in the companion zoning case, Seaport 1, required that the mayor's office produce all of their emails relating to these meetings. They have every email from Landmarks and from the mayor on these emails. And guess what they did after reviewing those emails? They said, sorry, Judge, we don't have anything. Let's cancel the hearing on this. They found no evidence of wrongdoing or impropriety. And they completely omit that from their papers. If there was something untoward going on, you would have seen it in the, right? Elliot Spitzer said it long ago. It's always in the emails, not one word.
What happened if you de-linked the project?
Your Honor, as a practical matter, well, first of all, de-link them in terms of the hearing in front of Landmarks.
I'll just say, forget it. We're just going to do the development. We're not going to bother with the Seaport Museum.
Well, then
That's one of the main arguments, that you got a quid pro quo. Okay, fine. You know what?
Not
doing that.
EDC made the decision that it was appropriate for the air rights that were being purchased from within the Seaport District to be the money from them to be used within the Seaport District. And there's an old concept of the Seaport District Air Rights Bank where air rights are allowed to be sold and that money is supposed to be spent within the Seaport District. It's what it was designed to do by the statute.
So the project was clearly dependent on the air rights, and EDC, not Landmarks, EDC had to think about whether or not they were going to sell those air rights. That's a totally separate decision on their part, decision making. They have a different, I guess, thinking on what needs to be done.
Exactly right.
You and Landmarks have one goal. EDC has another goal.
That's exactly right. And Landmark's job was to determine whether this project had the architectural and aesthetic elements that made it fit within the district. And I think, Your Honor, the focus on the virtual street level walkthrough was a game changer for them. Looking at what this was going to look like from within the district changed everything. This clearly was going to create a cohesive street wall that was going to be much better than that ugly parking lot before.
Okay, thank you. Thank you all very much.
Thank you.
Appreciate it. Zinger versus Robertson. Good afternoon.
Good afternoon. Howard Benjamin on behalf of the defendant appellant. There are two basic issues I will address before this court with respect to the lower court's dismissal or denial of the order to show cause, which sought specific relief relating to two basic issues. The first one being the alienation of the three children by the mother. The second one being the substantial change of financial circumstances by the plaintiff.
Starting with the first one, counsel, weren't 26 of the 31 instances cited by your client settled by this party stipulation of settlement, so they're off the table?
They were not settled in that stipulation, Your Honor. They were referred to, there was never a finding one way or another as to the...
They occurred before the stipulation of settlement was signed, correct?
Excuse me?
They occurred before the stipulation of settlement.
They were not heard, they were part of the...
I'm not finished with the question, just to be clear.
Yeah.
They occurred before the stipulation of settlement was signed, correct?
I'm sorry, I have trouble with one.
The 26 of the 31 instances cited by you occurred prior.
Yes.
The stipulation being signed.
That's correct, Your Honor. But they were not determined by the court as part of the resolution of that matter. Plus, the relief requested by the plaintiff appellant in that matter was totally different than the relief requested in the matter that before the lower court. The basis for what we believe should be the remand for an evidentiary hearing is that the lower court erred in determining that there was no prima facie case presented. Even on the 6 instances that were not part of the 31, there are no specific responses, there's no denial, there's no admissions, but bottom line is from a factual perspective, my client has virtually no relationship with his children. He has been denied access to them repeatedly and intentionally and willfully.
Well, I mean, the court found that there was no real evidence that you or your client submitted to actually prove that. Just said things, and yet he really did see the children when he went to Milan. I think the children live with the ex-wife in Milan, correct? And he did see the children in August, so it was unclear what you were talking about, not having access to the children. And the older daughter, I think, is already in college in England, at least at the time of this hearing, and she's over 18 now, certainly, but there was no indication or any evidence to back up any of your claims, and I think that's why the judge felt it was not necessary to have a hearing before making his determinations.
That's correct in terms of your interpretation, Your Honor. But the fact is, there were instances that were laid out. My client has not seen his daughter or spoken to his daughter for 3 years, despite reaching out. I don't know what kind of corroboration you require to at least have an evidentiary hearing on statements that are made under oath by my client, that he has no access whatsoever. That doesn't happen out of the blue.
She's emancipated, right? The daughter? Isn't she?
I'm not sure. Let me just... No, not...
Well, the older daughter is over 19.
The oldest one was born November 2nd.
This one is 20, and the twins are 18.
Yeah, we'll be 20 in November.
Right.
And the twins are
18.
Yes.
So they're all emancipated.
No, they're not emancipated. Well, I don't know.
They can vote with their feet.
Yes, and I don't know what the law is in Italy because New York State no longer has jurisdiction over them for reason of custody, etc.
Unless teenagers are different in Italy from the U.S., teenagers tend to do what they want to do a lot of times, right?
Certainly.
I'm not going to argue.
Certainly at 18.
We were all teenagers once.
Yeah.
I'm not going to argue with that.
That's right. So,
But it's not
we're not dealing with 10-year-olds.
Well, it's not a question of custody anymore.
No, it's not.
It's a question of, frankly, punishment for misdeeds that find my client in a position where his relationships have been destroyed with his children by the mother. My red light is...
All right, let's hear from your adversary, and you'll have a couple minutes to respond. Thank you.
Good afternoon. May it please the court. Ian Steinberg, Berkman, Botker, Newman, and Schein, on behalf of the respondent Juliana Zinger. Your Honors, the law as it relates to the suspension and modification of support obligations is well settled. We're dealing here with 18 and 19-year-old children who moved with their mother pursuant to the parties' agreement to Milan in 2017. To date, the father still has not moved to Milan.
He was supposed to. That was the anticipation.
Yes, Judge, that was the anticipation. He moved to Rome. It's
a lot closer than New York.
It certainly is, and it's a 2-hour train ride away. And the fact of the matter is, he didn't take advantage of the opportunity to see his children. The mother has never restricted the father's access to the children, and the standard under the domestic relations law.
Well, that's what you say, and he says she has. So, I mean, should there have been an evidentiary hearing to make that determination, or was the virtual hearing that you had sufficient?
Judge, I think that it was sufficient and that the prima facie case was not made. The burden is on the move-in in this instance.
Well, what would he show to, I mean, what would you have anticipated he would have needed to show to make a prima facie showing of that your client was interfering with his access or his visitation with his children?
Georgia, I think he would show actual instances in which the mother herself, and that he has personal knowledge that the mother herself actually said, you cannot see the children.
Emails, texts, something like that?
I would think that would be sufficient, or at least sufficient to have shown a prima facie, to make a prima facie case, and absolutely none of that was attached to the motion. It was just self-serving
Well,
statements.
and especially when you're dealing with children of this age living in a social media world. I mean, if in fact the father is saying that my kids don't want to see me, or the wife or the mother is preventing me from seeing them, I mean, it's out there somewhere, right? That he could probably get something, that kind of information, that kind of evidence. I didn't think the judge got any of that.
I think you're correct, Judge, especially in a world where people are texting and emailing. There certainly were opportunities for the father to show that the mother did in fact restrict or deliberately
Yeah, there was
frustrate.
one comment where he said that the mother did not give him the cell phone number of the older daughter.
That's
older
what
child?
that's what he said, Judge. I mean, he has the email address, he has the WhatsApp. There are plenty of ways in which he could have contacted his 19-year-old daughter, and I don't think that that was the mother who was stopping him from doing so. And as Your Honor said,
You can always run to court and say, Judge, I need you to tell her to give me the cell phone number. I don't think that happened.
it did not, Judge. And even in the allegations that were brought up, the ones that had taken place or that he alleges, I mean, one of the allegations says that he only let me see the child, but on March 18th. And I saw the twins from 8/16, 8/19. There's instances in which the father has the opportunity to see the children. He's just not taking up, he's not actually seeing them of his own volition, not because the mother is stopping him from doing it. As it relates to the financial claims that the father had made, the domestic relations law is also very clear as to what is needed in order to modify both a child support and a spousal support obligation. Here, there was a separation agreement, a financial stipulation of settlement executed by the parties, and so in order to show that the spousal support should be modified downwardly, there has to be a showing that there was extreme hardship. Nothing within the record shows that there was extreme hardship. And
Type of financial situation on the father's part.
correct, Judge, and he, the statement of net worth annexed to the motion shows that the father drives a Tesla, he lives on Central Park South, he has a place in Rome, he has a place in Sardinia. That is not who the statute's not seeking to protect people in that instance, and quite frankly, there would not be extreme hardship shown if the father has to continue to pay his spousal support. And similarly, as it relates to the child support obligation, there has to be a change in circumstances, but also an unanticipated change of circumstances. And here, the father says that he had to give half of his 80% of his assets to the wife. He has to prepay the health insurance for the children. Those were all things that were negotiated as part of the separation agreement, and so they can't be unanticipated. So we'd ask that the court affirm the lower court's decision.
Okay, thank you. Mr. Benjamin, you have 2 minutes.
Yeah, just briefly on the financial aspect.
Sure.
My client lost over $3 million, in part because the final payment that was due on the settlement agreement, I believe, was $6 million, which was due in March of 2020. And at that time, COVID hit, the market tanked. He asked for a very, very short extension of time to recover to some extent because the margin calls were going to cost him at least $1.5 million. Plaintiff refused to give that extension, and he had to liquidate, and he did lose $1.5 million. He also he's an entrepreneur. He does startups. He does businesses. He had one he was starting up that he anticipated was going to do well. Unfortunately, his programmers were all located and lived in Russia, and we know what the story is what went on with the Ukrainian war, which was clearly not an anticipated circumstance. Thank you.
Thank you. Thank you both. Next case for argument is Optical Communications.
Good afternoon, Your Honors. My name is Victor Worms, and I am the appellant in this appeal. This is a legal malpractice that was brought against me personally and against my law office by the plaintiff. The central issue on this legal malpractice claim is that somehow I was hand-delivered documents that were supposed to have been exchanged in discovery, and that I did not provide that to the plaintiff in the underlying action, and as a result of which they could not offset their supposed costs, and therefore I'm liable. But if you take a look at the record, Your Honor, there is a consistent instances repeated in which they were never able to produce any of their costs in connection with the MSA because they didn't do the work. It's that simple.
Well, it is a pleadings motion, though. So rather, it's a pleadings motion, it's a 3211 motion. So we're not really looking at the record. We're looking if they pled a cause of action.
Except there's one instance, though, and that is the documentary, 3211A1, which is documentary.
No, but some of what you provide as documentary evidence are EBT depositions and affidavits, and I don't think those qualify as documents for that purpose.
Well, there's also court records as well, which do indicate that there was no compliance in performing. For example, if you take a look at the lower court's decision, which is on record, you'll see the court says specifically that there were testimonies and emails which indicated that the work had not been done. So it's not just emails and depositions, but there is consistent court records and testimony at trial in the form of deposition transcripts, which do indicate that the work was not performed. For example, if you take a look at Mr. Payne's testimony, which is on R558,
you're saying the documents don't exist. In other words, this lawsuit here is based on the fact that their claim is that you didn't turn over in discovery documents that would have provided them with a set-off. And your argument, at least you're saying that the documentary proof in this lawsuit here is that there were no documents to back them up.
Actually, that's a great point, but it's actually two things that I'm saying. I'm saying that in actuality, they didn't do the work.
But they did claim that even if they didn't do all the work that they were supposed to do, seems to be what may be the case, that they are claiming that there was still potential offsets to the ultimate large damage judgment that was issued against them in the other case. So what I understand their claim, at least part of their claim, is that there were documents out there that were produced to you that had they been available, there could have at least potentially been an offset because there was certain work and certain outpourings of money that they made prior. And that's how I understood at least part of their claim being. They may not have won the case, but there may have, the damage award may not have been as significant,
actually,
at the least.
Actually, prior to the actual trial, there was a mediation before Judge Branstein, Eileen Branstein, right. And she specifically said, bring me all the documents you have, because her proposal is that we're going to offset whatever work you did, whatever cost you had, against the $150,000 that you paid.
Who was supposed to bring all of those documents to Judge Branston?
Well, that would have been brought, they had never provided any documents.
But what they're saying is that they gave you the documents and that you should have had it and provided it to Justice Branston.
No, actually, Your Honor, if you take a look at the record, you'll see that in response to the second discovery request, the second discovery request was where the PEG plaintiff in the underlying case specifically requested their costs and their expenses, and they couldn't produce any of.
Wait a second. So that trial, and looking at this record here, you had tried to introduce documents, and the court said no.
No. That's not an accurate statement in respect to the costs. Specifically, the costs that the court requested, they never produced that. If you take a look at the evidence in this case, you'll see that Mr. Honeymeyer said in response to the second discovery request that I am sending you by email all responsive documents. So in respect to your question, they never produced that because in actual fact, what occurred was in the second deposition, the second discovery request specifically called for costs and expenses.
I got in my notes here.
Honeymeyer,
I got in my notes here on the second day of trial. During Ickey's testimony, counsel, that would be you,
right,
sought to introduce evidence of OCG's costs associated with an extension of optical fiber, whatever. And that PEG, the plaintiff in that case, in the underlying, objected to Ickey's testimony, stating that such documents were not furnished in discovery and that during Ickey's deposition, he stated that he was not sure of his expenses. The court then asked whether they were produced, and your answer was no, and therefore the court, precluded it. So at some point in time, you got the documents.
No, that's not a correct statement. I'll tell you exactly why.
Well, then I
No,
wrote it wrong.
you've read, what you've read is correct, but what actually occurred is not what the record reflects. Specifically, Mr. Hickes came to court that day to go to Judge Branstein. That's the same day we were before her. He produced those documents to her, and she said, this doesn't show any cost and expense.
But Judge Branson wasn't the trial judge.
No.
She was trying to have a settlement conference before it went to trial. And at trial, it seems that there's at least an issue. Maybe you're going to win the case, but you're looking to dismiss it before we've gotten anything done. Let's hear from your adversary, and you'll have a few minutes to respond to him. Okay, Mr. Worms? Thank you very much.
Good afternoon. May it please the court. The complaint is replete with citations to the transcript where counsel attempted to put in documents and was precluded because he couldn't say whether they'd been
At trial.
At trial. Mr. Ickes came with paper documents because he saw what happened the first day and said, here are the documents I gave you, basically. I want to put them in. He tried to put them in. They wouldn't go in. They were precluded. Mr. Ickes testified to his costs. The judge recognized his oral testimony, but she would not grant him his relief because he was not supported by documents.
So, I mean, these would have been offsets to the judgment that ultimately was...
almost $650,000 in offsets, yeah, exactly.
And counsel, I know that your complaint alleges a number of times that, counsel here, appellant was timely provided with the documents. They were never served, and that's why they were precluded.
Yes.
My question is, did counsel here produce any documentary evidence to utterly refute these allegations?
No, he did not, Your Honor. And we know that at record 78 and 466, there were emails with lots of documents that were sent to him that he has never explained what he did with.
The March 21st, 2018, I know that was an email. And there
Page
was a
78 and
response.
466 of the record. Mr. Honeymeyer sent him emails with documents. And he also, Mr. Ickes testified in his affidavit, here in the motion, that hand copies were taken as well.
So there's an issue of fact.
Issue of fact, sure. At a minimum. And yes, the judge said there may be a credibility issue raised in the motion, but for pleading purposes, it's a perfectly good complaint.
Okay.
Thank you.
Thank you. Mr. Worms, you have a few minutes.
Yes, Judge. The crux of their claim that they hand-delivered these documents to me is an email dated April 3rd, 2018, in which you see there's reference to the trial. So you have a reference from April 3rd, 2018 to a trial that's taking place on May 31st and June 1st. So there is an inexplicable reason why an email written, and that email, by the way, doesn't indicate how it is possible to have an April 3rd, 2018 date on an email making reference to transactions occurring at the trial on May 31st and June 1st. That is the crux of their claim that they hand-delivered the documents to me. Let me address something that was raised previously. No one saw the documents that Mr. Hickey's claim were his costs and expenses. If you look at the record, at no point in time were they ever able to give any costs and any expense relating to the online transactions because, as the PEG officers testified, they didn't perform
Let me ask
the
you,
work.
I thought in the record, I saw an email from September 9th, 2017, where Mr. Hannemeyer sent you documents, and he included in an email, and he said, I just sent over my draft and documents in response to the to the plaintiff's request. So what happened to those documents?
Sent them on. They were all Dropbox documents that were sent to the plaintiff in that case. And in fact, if
So why did the plaintiff say at trial, I don't have these documents, and you can't put them in if they have them? And
That's a great question. The question is, what happened to those documents? Those were the documents that were forwarded by email to PEG. They're saying that they gave me separate hand documents by hand. So you see the issue here. The issue is that what I got, I gave, and had I not done so, there would have been a motion to compel or for sanctions because that was in response to a specific document request, the second document request, which I was given these documents and I forwarded them on to PEG. So therefore, had I not done so, there would have been some discovery sanctions against me for not having done that.
Okay.
So the handwritten documents that they claim they gave to me is based solely upon a fiction.
Okay, we'll take another look at these documents. Thank you both very much for being here this afternoon. And our last case for argument, even if I didn't say that, I think you would have figured it out, is People versus Sherman Harrison. Good afternoon.
Good afternoon, Your Honor, and may it please the court. My name is Leonard Simmons, and I represent Appellant Sherman H. in his appeal to overturn the lower court's finding of dangerous mental disorder pursuant to CPL 33020. Sherman H. is unlike any 33020 respondent to ever come before this court. The trial court erred in finding that Sherman H., then a 39-year-old father and accountant from Maryland, exhibited the highest level of dangerousness recognized by the statute, where all four testifying forensic examiners unanimously agreed that he was stable and asymptomatic for nearly 3 years leading up to and throughout the initial hearing. Sherman H. could not be found to meet this heightened level of dangerousness where he was asymptomatic, stable, had no violent or criminal history beyond the instant offense, had no diagnosis of substance use disorder or personality disorder.
Well, Dr. Lee and the other doctor for the institution both said that he should stay at Kirby. And one thing that Dr. Lee said in particular was, well, they both said there was a lack of insight by your client, but Dr. Lee said also because your client had been so high functioning in the world that he had a functional reserve, I think is what the Dr. Lee used, and basically saying that he could front and look like he was able to be out of the institution because he wasn't a danger. So, I mean, isn't that enough? This is a very lax or very easy standard of review for the institution.
No, Your Honor, I don't think that is enough. First of all, even though they both found that he lacked insight, there was plenty of doctors to find that he did have good insight. His own doctors, Dr. Green, Dr. Siegel, even the DA's doctor from the underlying criminal proceeding, Dr. Khedivi, found that he had good insight. That's 3 doctors, including one of the DA's own doctors from the underlying proceeding, that found that he had good insight.
In looking for who has the preponderance of the evidence, the court could credit the Dr. Lee and the other doctor who testified with him.
The court can, Your Honor, but this is a de novo review, and I do believe that there's plenty of reasons to doubt their own evaluations. And remember, both Dr. Lee and Dr. Wilson, these are the DA's experts, both of them were trainees at the time. Both of them were being supervised. Together, they had only done 3 such evaluations in their entire careers.
You know, with this kind of exam, this kind of mental health exam, it's very important to be in the room, or at least examining, or at least having a conversation with the individual. You wouldn't disagree with that, right? I mean, you agree that that's important.
Absolutely.
That personal connection. In this case here, Dr. Lawrence Siegel, he did it by remote. He remotely interviewed the individual, unless I'm mistaken with my notes here.
No, I do believe that's correct.
That's a remote interview. I mean, counsel, we're talking about a psychiatric evaluation here doing remotely.
I mean, I will say that Dr. Siegel had conducted over 1,000 such examinations.
You know what? It's this case that I'm concerned about. I'm not worried about all the 1,000 other cases, but this case is something that, as you say, is it's intense. It's a big deal going on, right?
That might have been preferable. I can't say exactly why Dr. Siegel.
And also, Dr. Green, Debbie Green, she interviewed him and he wore a mask throughout the entire interview, so that she could not even see his expressions and how he was reacting to the questions. So that kind of takes away a little bit from the evaluation too, don't you think?
I believe that may have been due to COVID protocols since he is in a hospital. I can't say for certain. I will note that, again, even if your honors credit the DA's experts here and you find that there is some level of dangerousness, there are 3 possible dispositions here, 2 different levels of dangerousness. The heightened level of dangerousness for dangerous mental disorder, the lower level of dangerousness for mentally ill, which includes a finding of dangerousness, and then track 3, no dangerousness, in which case he'd be released to the community. And the cases from the Court of Appeals show exactly what these different levels look like. They set out the factors very clearly, and we need look no further than the Court of Appeals decision in David B. David B. was diagnosed with paranoid schizophrenia and he attempted to murder his brother and flee the scene. He suffered from paranoid delusions about the FBI and the CIA even while he was confined. He refused to take medication. He denied he had a mental illness. He was prone to angry outbursts and had unexcused absences from the facility. That, the Court of Appeals says, is the level of dangerousness associated with civil confinement, which here would be track 2. Sherman H. has none of these things. He has no violence. He has no, everyone agrees he's stable.
Well, I mean, it isn't so long ago that this terrible accident occurred, and that's one of the factors we're supposed to consider. How long ago was the incident? That particular day was very violent. He had guns in his car. He said he was trying to fly to the moon. He was racing 113 miles an hour on, I think, on the West Side Highway, and he killed a woman, and his car completely exploded. He's lucky he survived. It came on apparently in a short period of time, so it would have been hard maybe for anybody to figure it out. I think this is an extremely serious situation. I think your explanation of it doesn't include some of the other points I might consider. And Dr. Green herself acknowledged on cross-examination that some of the defendant's statements were contradicted by Kirby records, as to how he was dealing with his medicine and his social anxiety and whether or not he believes he'll ever have a relapse. So I'm concerned because of the different factors we are required to take a look at as set forth in several of these cases.
If I may just
answer,
respond,
yes.
I do believe that what Dr. Green was saying, that some of what Dr. Mortier was saying, who didn't testify in this case, but some of the excerpts from her notes were contradicted by more thorough explanations that Sherman H. had given in the record. With regard to the instant defense, that is absolutely something that this court needs to consider. We never dispute that. George L. makes that very clear. However, George L. does say that neither the nature of the prior criminal act nor the statistical probability of relapse standing alone is sufficient to establish current dangerousness. It sets out other factors that need to be considered, such as relapses into violence, medication noncompliance, substance abuse, and Sherman H. meets none of them. There have been no relapses into violence. He has only been medication compliant.
But what about the Carpinello versus Floyd, a First Department case from 2005, where we found these various factors that we're supposed to consider: the nature and recency of the patient's criminal act, the history of relapses, history of drug use and other dangerous behavior, the patient's insight. I mean, all of these things are supposed to be considered by the court. I mean, there's a lot of factors we need to take into account in making this important decision.
Absolutely, Your Honor. But almost all of these factors weigh towards a finding of either no dangerousness or at least the lower level of dangerousness. Again, a lot of these cases talk about relapses into these things, relapse into substance use after release, relapse into violent behavior after release, not taking medication after release. This is an individual who was an accountant and a father who led a law-abiding life for nearly 40 years before his first and only psychiatric break.
I understand, but let's listen to the other side, and you'll have a few minutes to respond. Thank you very much, counsel.
Good afternoon, Your Honors. Excuse my voice, it's not 100%. Sylvia Wertheimer for the people. The record amply supports the hearing court's very well-reasoned decision. It's a 16-page decision that the evidence showed by a preponderance of the evidence that because of his mental illness,
Could you put the microphone a little closer to you?
that because of his mental illness,
That helps.
Defendant presented the dangerousness at that time required for a Track 1 designation. I think Your Honors have already pointed to some of the factors. Yes, the nature of the crime and the statistical likelihood of relapse by themselves are not sufficient, but defendant completely ignores them. Here, these were very important, especially because, as Justice Kapnick said, it was only 3 years since this happened. This was a terrible crime. He incinerated this woman, drove into the back of her car at 113 miles per hour, and during this psychotic episode, there were other instances of extremely violent conduct, including one instance of reckless driving, where he was driving at over 100 miles per hour for 27
All these
miles.
incidents happened within a compressed period of time, and they were aberrational given his life. You'd concede that, right?
Yes, you can see that, but these things show that when the defendant has a psychotic episode, which there's a 93% statistical likelihood he's going to have again at some point, that he's likely to engage in extremely reckless, dangerous conduct.
I mean, you'd also agree that not all manic episodes are created equal. People who have bipolar 1 disorder could have a different kind of manic episode that may be of no danger to anyone else.
This was the one and only.
Right, no,
manic
but you
psychotic
said that
episode
there's
he had,
often...
and it was-
The point that you made was that there's recurrence. When there's a diagnosis that's confirmed bipolar 1 disorder, 93% of the time there will be another manic episode. What I'm saying to you is that the manic episode may be of a totally different character in which there's no danger to either Mr. Sherman.
I'm not sure that the record suggests that it could be of a totally different character. I think the witnesses testified that it was likely to be of the same character. The character of the prior episode was symptomatic of what the future episode would be. I don't think there's any case where a defendant has been released into the community 3 years after committing a dangerous act, a deadly crime like this. And then there are other factors in this case, in addition, where with the problematic medication rate of compliance at Rikers Island, which is an issue of contention between the two of us, and the lack of insight. And the fact of the matter is, and also I just wanted to say, defendant emphasizes no symptoms, no relapse since he became stable. But of course, for all that period of time, he was in an institutional setting. And George L. says you have to take that with a grain of salt, because in an institutional setting, he's being given antipsychotic medication. He has a very big incentive to behave. That is not an excellent predictor of how he would be if released into the community or even if stepped down to another level. And the medication compliance rate is very concerning. At Rikers Island, at times, the medication compliance rate was as low as 30%. For over almost 2 years, it never reached 100%. Somebody who really appreciated the importance of antipsychotic medication to his illness would have at least complained about that. And now, and they say, defendant says, oh, we shouldn't just look at the records because the records might not have said that. But when defendant talked to all the psychiatrists in this case, the examiners, he never said that he had complained about not getting medication. And this is a significant amount of medication not to get.
So if people commit this kind of violent crime and then end up being in a secure facility, how are they ever going to not be? How are they ever going to be be able to make this proof that they can exist outside if they're not outside?
Well,
I mean, how do they do that? Is it just so many years pass without any new situation that people say, okay, I guess enough years have gone by, now you can go out? I mean, you're saying, well, we're evaluating him, but he's been confined in a secure facility all this time. How does he ever get out of that secure facility?
Right, I think he gets out of it by showing to the people treating him at these facilities that he has developed good insight into his illness, that he doesn't have superficial insight, he's not engaged in impression management. Here, I think it was very important, all the people who treated him at Kirby, who had the closest connection with him for a period of time, professional, said that he got superficial insight, that he engaged in impression management. He did not think he would have a chance of relapse, that the social worker said she worried what he would be like outside of an institutional setting. The whole point of this scheme is in a secure forensic facility, you're supposed to get a type of treatment that will enable the defendant to develop the insight that will allow him to move on and at some point be released into the community. Nobody's saying that he should stay forever. This was for 6 months. There's already been an application for a retention order. So what has to happen here is he has to more meaningfully engage in treatment and convince the people who are treating him that he has sufficient understanding of the gravity of his illness, that he can be trusted to be starting to go to the next step.
He has the keys to the lock, basically. That's what you're saying.
Yes. And so therefore, the record amply supports the Commitment Court's well-reasoned decision, and the decision should be affirmed.
Thank you.
Your Honor, with regard to the idea that this court is required to release him to reverse this case, it's simply not true. If this court finds that he presented dangerousness, if you credit the DA's experts that he is dangerous, if you find that he meets the lower level of dangerousness, which again, we talked about in terms of the factors of David B., that would still require reversal, and he would still be confined at a civil psychiatric hospital.
So that's a non-secure facility, is that what that is?
It's a bit of a misnomer. We're still talking about locked wards, barbed wire
But is that,
fences.
oh, okay.
Yes, it is technically called a non-secure facility, but it is a bit of a misnomer. Second, with regard to the medication compliance at Rikers, the DA says that it finds this concerning, but its witnesses surely did not. Its witnesses said that they would not blame him even for as much as the 30% compliance rate, that the Rikers records were pretty poorly documented, and that given all the systematic problems at Rikers, they weren't surprised that this happened.
No.
The DA also says, well, why didn't Sherman H. tell the doctors that he was concerned about this? And the answer is that he did. He did tell the doctors about this. When they interviewed him, he told them that there were issues. It shows up in one of the doctor's notes where Dr. Wilson confirms from their evaluation, this is on page 535, that his note stated, missed doses due to logistics at Rikers, but not intentional. No missed meds at Kirby. So this is, again, there's no records that he has ever.
The thing, I asked my question to counsel about, how does he ever, if he stays in a secure facility, be able to show that he can be outside a secure facility? But the tester, so she said you have to convince the people that you're working with that you really are getting better. So here he's in the facility, and all the people that are his regular treating physicians, psychiatrists, are concerned. You bring in people who saw him just once or twice and saw him with a mask, and one saw him virtually. I mean, how did they not meet their burden under these circumstances?
Well, a few things. First, Sherman H's treating psychiatrist, Dr. Lonati, stated that he, quote, doesn't see the possibility of future decompensation as an issue. That's in the record at 394. I think that means quite a bit. Second, they did say that they had concerns about his insight, and they give some quotations as to why, but none of them testified, and none of them said that their concerns about his insight rose to either level of dangerousness, that it met either the lower level or the higher level. Finally, I would note that even if your honors have concerns about his insight, that could still mean and should mean that he would be treated at a civil psychiatric facility. We can see this, if I may just sum up, in Glen B. Glen B is a First Department case where this court found that someone needed to, the respondent needed to remain in a civil hospital because of limited insight, demonstrated by the fact that he had no remorse, took no responsibility for his crime, was non-compliant with medication and had to be injected with antipsychotics, and that his medical records were replete with notations of volatile behavior. This court found that that is the level of insight and dangerousness associated with a commitment to a civil hospital. And Sherman H, again here, meets none of them. He's never refused medication. He's completely compliant. He does show remorse, calling the crime horrific and tragic. He takes responsibility for his crime, and 3 separate doctors found that he had good insight. So even if that is credited, we believe that that enough is grounds for reversal and finding that he is tracked to and should still be confined, but to a civil psychiatric hospital. Thank you.
Thank you. Thank you both.
Thank you.
Hi.
You too. Have a nice night.
Hear what?